It to mention one listed motions 879, very urgent.
Give your slip.
Yeah.
Give your slip. Give your slip.
My lord, mention, my lord, these matters. My lord, in the month of May and June, I have mentioned this is for, my lord, the non-payment of arrear dues. They are, my lord, facing financial problem. My lord, completion certificates are there. I am covered by your lordship's judgment. Your lordship, kindly let it be upgraded, my lord. This is the third time I am mentioning these matters.
There are more important matters, madam.
Mentioning the matter thereafter, I filed one urgent application. The thing is that threat to lawyer is the undermine justice. Threat to lawyer is the undermine justice. Is a threat to administration of justice. The second time writ petition where I challenge the order of the municipality without having any sanction plan. That has been.
Your
lordship, one of the promoters.
All matters are serious for us, sir. Give your
Your
slip.
lordship,
May I be permitted to mention?
Give your slip.
I have been
Permitted
mentioning
to
for the last
mention
few
one
weeks
matter.
one item. The special officer has been occupying, and yes, this thing transferred the our car parking space into a restaurant, and we are suffering very heavily. And the special officer is not entitled to hold his office beyond 6 months. For 62 months, your lordship, he has been holding office,
Give your
and
slip.
I have.
My lord, item number 1774 of the monthly list, my lord. What had happened, my lord? Initially, I was arraigned as accused on the charges of forgery and Foreigners Act. I was taken to custody. Subsequently, I was released on bail, my lord. After releasing on bail, my Aadhaar card and Epic card were cancelled. By an order of this honorable court, that was reactivated. Now the KMC has deactivated my birth certificate without giving any opportunity of hearing, my lord. Next date before the Lord Court is for consideration of the charge, my lord. Kindly upgrade, my lord.
My lord, may I be permitted to
Give your
mention this matter? My lord, this is from my lord Justice Chando's determination. This is new electricity connection. The petitioner before your lordship is a my lord, person of our fraternity. My lord, he has purchased a new my lord, new house. Well, it's actually an old house. My lord, newly he has bought. My lord, he is not getting electricity connection because the erstwhile owner, my lord, his payment is due.
Sir, what is the urgency?
My lord,
What is the urgency in this?
my lord, new
When did you buy the property?
my lord, I have purchased this in August. My lord, it has been
August of last year.
August of last year.
Yes.
My lord, the WBACDCL has
Yes.
informed me, my lord, only in this May month.
In May month.
May.
You can wait for the regular bench to come. What is the urgency? You have bought the property.
Milord, may I be permitted to mention item number 2501 of the monthly list, Milord?
Give your slip.
Milord, kindly see, Milord, the condition, Milord, my house is breaking due to, Milord, illegal construction, Milord, by private
your-
respondent,
give
Milord,
your
despite
slip.
orders of various court, Milord,
Give your
of injunction. Milord, kindly see.
This is, my lord, this is.
Give your slip, sir.
May I have your lordship's kind leave, my lord? May I?
My lord, this is, my lord, an
Give your-
unauthorized construction by a club. My lord, your lordships called on 24th. Due to my illness, I could not present before your lordships, that your lordships adjourned it after 8 weeks. As a kindly, my lord, upgraded it. My lord, this is a unauthorized construction by club, totally blocked my ingress and
Give your
egress.
slip, sir. If you are
Yes,
not
Lord.
there, you
Kindly,
can't
Lord.
there.
May I be permitted to mention, my lord?
My lord,
Give your slip.
may I have your lordship's kind leave?
Mention, my lord. I
Give your slip, madam. Give your
May
slip.
I be permitted to mention,
Lord,
my
may I
lord?
be permitted to mention?
For the third time, my lord, it's a contempt application. Kindly include in the list.
Give your slip. We'll see that.
I mention, my lord, one
May I
matter.
have your lordship's kind leave, my lord? My lord, this
Exclusion.
Inclusion. Give your slip.
My lord, may I be permitted to mention item number 2322 of the monthly
Give your slip, sir.
the urgency is, lordship. I'm a developer, my lord. On a regular basis, I am suffering commercial loss because of I
Very
am
good.
obstructed from entering my property, your lordship, to construct.
Very good.
This is the difficulty, your lordship.
Give your slip.
my lord, this matter has some urgency, my lord, because I have bought a house in the month of May. I have entered into a contract for lease.
What do you want? Give your slip.
My lord,
Give your
some
slip.
urgent listing, my lord, because I'm a septuagenarian person, my lord.
Give your slip. Give your
My lord,
slip.
kindly be listed, my lord. So-
Give your slip, sir. Give your
But I have
slip.
constructed,
Give the
Your
slip.
but I've constructed a building according to the sanction plan. For the last 4 years, CC is not being given to me. And for this reason, my lord, I'm getting hauled up
Give
in
your slip.
litigation before RERA. 9th is the date fixed, my lord.
Give your slip.
Your lordship, your lordship, there is an extreme urgency that tomorrow eviction will be drive for the evict the petitioner. Petitioner is a hawker, street vending. protected under the Street Vendors Act.
Give your slip.
Your Lordship, I am also handing over the eviction notice who's going to be held on tomorrow. Your Lordship, kindly take up the matter tomorrow. Your
Your slip
Lordship,
will see that.
My lord, may I mention one matter for non? They're drawn up and completed.
Give your slip.
it's a
My lord,
humble,
one more application, my lord, restoration.
it's a humble request. Your Lordship, kindly take up the matter tomorrow. The petitioner
Smith,
livelihood jeopardized.
The application for inclusion in the district.
Give your slip.
My lord.
Yes.
My lord, might have your
Yes.
lordship indulgence to mention a matter.
Sir, give a
But
slip.
statutory appeal, my lord. I'm giving the slip.
Your lordship,
I'm giving the slip, my lord. Statutory appeal. I'm giving.
your lordship, there is an urgency in matter. This is an unauthorized construction
Give
building.
your slip, madam.
And your lordship, there is extreme urgency.
All unauthorized
So
construction.
it's an
is
original side matter, my lord. I require your lordship's leave for drawn up and complete, my lord.
Original side,
Original side matter.
not
my lord.
today.
My lord, drawn up and complete only, man. My lord, only that.
Drawn up and complete.
Drawn up and complete.
Your lordship,
My lord, I have taken a loan, my lord, to construct a stadium, my lord, but my lord, the loan is not being paid, my lord, by the municipality, my lord.
Very good.
My lord, please,
Give
my
your
lord,
slip.
urgency, I'm not able to pay, my lord, EMI, my lord.
your
My
lordship,
lord,
I'm seeking leave to mention one matter for upgradation. Your
Give
lordship,
your slip, sir. Give your
I
slip.
permitted to mention an urgent matter, the matter.
Give your slip.
My lord, upgradation of the matter, my lord. Thank you, number.
Call out the list. Tomorrow.
I appear on behalf of the petitioner, my lord. Affidavit service. Affidavit service.
Yes.
Affidavit service. The affidavit.
But I am appearing. Exponent number 10 and 11. Private.
Yes.
My lord, kindly see the annexer P4, page 40 and 41. Unauthorized construction over the courtyard. May I read it, my lord?
Yes.
They have to take step to render police help to a petitioner by which the below mentioned person may not encroach the joint HON'BLE land classified as courtyard in premises number 70 and 72 of Mahendra Bhattacharya Lane, Howrah, through forcibly construction of cemented floor on the said ground with a view of install a big water tank containing 2000 liter water by making adherence to all the joint owners use. Name of the persons making unauthorized construction over the courtyard in the occupation and enjoyment of the petitioner, namely Dilip Chander, son of late Jivan Krishna Chander, and Boisali Chakraborty, wife of Sri Prabir Chakraborty, both of 70 Mahendra Bhattacharya Road. Thereafter, Kullani Sil, wife of petitioner. Respected sir, I beg to draw your kind notice that I and other person are the joint owner of the courtyard in premises number 72 Mahendra Bhattacharya Road, Post Howrah, PS Chatterjee Har, District Howrah, 711104 as per deed of partition executed in the year in between all four owners by partition deed number 6541 for the year 1962. In the said deed of partition, a courtyard is shown in sketch map for the use of all co-owners, and I am one of the owners of the said courtyard. The courtyard is to be used by all the co-owners free from all incumbents and also free from any hindrance from any of the co-owners of outsider. Dilip Chander and his wife and married daughter, namely Boisali Chakraborty, wife of Prabir Chakraborty, jointly by using their muscle power, have started concrete cemented floor construction encroaching the front side portion of the petitioner with a view of to install the 2000 liter water tank, which will create inconvenience to all the co-owner, including the petitioner. The aforesaid Dilip Chandra and his associate have given serious threatening to this petitioner, a 80 years old lady, and encroached the portion of the petitioner. There is a chance of serious breach of peace if the co-owners try to resist the illegal work of construction without permission. So I do help hereby pray, please take appropriate step by which the said persons cannot construct the cemented floor over the joint use of land, all the co-owner. This is my contention, my lord. Grievance.
Who appears for the corporation?
And I'm for the statement, I've got the report, my lord. Police report.
What is the report?
My lord, this is a sketch is there. This is a small tank. The officer in charge has said this is small tank. My lord, report is very clear, my lord.
And
My lord, this is not the construction. But kindly see, store a small container to store drinking water.
My
At
lord-
his own place,
my lord,
not in the courtyard,
my lord,
not in the common passage.
my,
He is misleading this honorable court.
my lord, kindly see the photograph, color
Yes,
photograph.
my lord, kindly see their photograph.
It is the
Misleading this honorable court.
my lord,
This is not the
color
construction.
photograph.
একই জিনিস দেখছি একটা কন্টেনার রেখেছে বলে আপনারা চলে এসেছেন এটা কনস্ট্রাকশন
Common courtyard মধ্যে vacant land.
কোটিয়ারটা কি কমন নেই ওটা প্ল্যাটফর্ম নট কোটিয়ার
Courtyard, kindly see the partition deed, sketch map.
There is no construction which is there, sir.
Yes.
What is the construction?
My lord, kindly see the color photograph. Water tank and create a cemented culvert. Kindly see the partition deed. 1962.
My lord, this is not the civil
Hmm.
court, my lord.
Demolition.
He went to the civil court and dismissed the
demolition.
judge. Suit. Suit the dismissal. Yeah.
Hmm.
This is a common area.
Common area.
What
My lord, courtyard.
Just a minute, sir.
Kindly see the partition deed.
Yes.
Partition deed sketch number. Partition deed 1962. 72 Mahendra Bhattacharya Lane and 70.
Consider his representation. See what is there.
Your Lordship, but the encroachment aspect we won't be able to do. If there is any construction
There is
without,
construction.
Your Lordship, then we can consider.
There is construction. He has built a,
Your Lordship.
not encroachment. He has built a
Water tank and
tank can't be kept anywhere.
culvert, cemented culvert. Water tank with cement
What, my lord, misleading this one. This is the platform.
slab.
Platform of the.
Water tank.
No. Misleading.
That
this
is
one.
not your area, sir.
My area, my lord. That is not.
No, my lord, courtyard one 1962.
This is the platform of the room.
Sir,
Platform.
this area is a common area.
This platform of the room.
No, my lord, courtyard. Courtyard,
This is not the courtyard. This is not the common passage.
courtyard.
ये देखो सब एक ही. No, this is courtyard, sir. What platform?
Courtyard.
It's part of the courtyard.
Courtyard, my lord.
Enter courtyard, my lord.
Under this, the courtyard.
Courtyard
is
vacant land.
counted.
And who has put this tank? The black one?
Black one tank, Your Lordship. Black-
Dilip Chandra and Boisali.
Who has put the black tank there?
Black.
There's one more tank.
Both tank they are private respondent, both tank.
Install this container, my lord.
It's a tank, sir.
For storing the
Two,
drinking water.
my lord,
This
two
is the care.
Sir,
tanks
you have to
they are.
you have to do it in your own property.
This is my own property, my lord. We
Common-
adjust
common-
to my- No.
Yes, see,
Common
if it is
passage.
encroachment, you don't do anything. If it is unauthorized construction, you remove it.
Kindly
Kindly clarify,
Manda-
Your Lordship, that we are not going to decide the encroachment.
So you decide whatever you have to decide. Why should I preempt any kind of decision?
directly remove the water tank and
All right. The petitioner, by way of the present
Kindly-
petition,
allow my prayer.
is aggrieved
Hmm.
by the inaction of the respondent authorities in failing to initiate appropriate action against the illegal and unauthorized construction undertaken at the instance of the private respondents, full stop. Specifically, a cement concrete platform being constructed for installation of water tank in the common courtyard situated on the southern side of the holding number 72 Mahendra Bhattacharya Road, under the jurisdiction of Chatterjee Hut Police Station, Howrah. Full stop. Full stop. The petitioner submits that she is the rightful owner of the aforementioned premises by virtue of a registered deed of partition, being deed number 6541 of the year 1962, full stop. As per the terms of the deed, there exists a common courtyard on the southern side of the property, full stop. However, on or about 22/9/2024, respondent number 10 illegally and unauthorizedly constructed a cement concrete platform without obtaining the requisite permission from the concerned municipal authority, full stop. Municipal authority and proceeded to install a large water tank thereon, full stop. This construction has materially obstructed the petitioner's rightful and unhindered right of usage of the common courtyard, full stop. Learned counsel for the private respondent states that he has not carried out any unauthorized construction, rather has only installed a water tank on a cement based concrete structure, full stop. He further states that he further states that the same has not been constructed on the common courtyard, full stop. Learned counsel for the state has filed a report. The same is taken on record, full stop. Learned counsel for the respondent, Howrah Municipal Corporation, states that they are ready and willing to consider petitioner's representation. What is the date?
27th of
Presentation
September
dated
2024.
27th of September 2024. Full stop. Learned counsel for the petitioner states that he shall be satisfied if the same is decided within a time-bound manner. Full stop. In view of the statement made by the counsel for the parties, this court directs who will decide?
The delegate of the commissioner, Howrah Municipal Corporation, Your Lordship.
The
9 and 10.
9, maybe 9.
10 plus
Respondent 9 may be
private-
competent to decide this.
8 and 9.
Engineer, Howrah Municipal Corporation.
8 and 9.
The assistant engineer.
Your Lordship, that
The assistant engineer, Havra Municipal Corporation. Respond number 9. To decide petitioner's representation
अच्छा हाँ
within a period of
8 weeks.
8 weeks from the date of communication of this order in compliance of strictly in compliance of the law, comma, in accordance with law, strictly in accordance with law, comma, after affording an opportunity of personal hearing to the petitioner as well as the private respondents by way of a speaking order, comma, by way of a speaking order. With the above direction, the presented petition is disposed of.
Grateful, my lord.
Corporation will be at liberty to inspect the property.
You have all the liberty. If it is encroachment, don't do anything. If it is unauthorized construction, take action.
Great.
বলছি
দাদা নাম কি?
Lordship, I appear for the petitioner. Lordship, this petition is under the Registration of Births and Deaths Act and the West Bengal State Rule there.
So how did this happen? 2 certificates.
Lordship, the entire instruction I have not received. My lord, keep the matter next week, your lordship. I'll come up with the relevant instruction.
I'll direct a police inquiry.
Lordship, let me come up next week, your lordship. Thereafter,
You cancel it, do the needful, otherwise
I'll come up with the proper.
you are in
instruction.
trouble.
I'll come up with the proper instruction, your lordship.
When do you want?
Next Tuesday, your lordship, if your lordship pleases.
Next Tuesday?
Your Lordship,
Next Tuesday.
Lordship,
Not today, next Tuesday.
lordship, much obliged.
Your Lordship, if I may hand over the affidavit of service to place it on record.
Next Tuesday.
Grateful. Obliged.
Next.
Lord, I am appearing for the petitioner. This is my affidavit of service.
But I am appearing on behalf of the respondent number 14 and 15. And also last occasion, your lordship direct with the municipality.
Yes.
Lord, over here,
State
my lord, the
respondent.
facts is that I have placed an allegation of illegal construction against the private respondents, my lord. I had made a detailed representation before the municipality as well as to the urban development department. Thereafter, your lordship, the assistant secretary of the department wrote to the chairman of the South Damda municipality on 24th of February, asking for an inquiry and a conclusive action taken report. Thereafter, your lordship, the sub-divisional officer also writes to the municipality's executive officer on the 8th of April for an inquiry. The municipality's executive officer conducts an inspection on 11th of April at 1:30 p.m. and a hearing had taken place on 25th of April, your lordship, which is annexed at page 46. Your lordship, on the date of the hearing, your lordship, the private respondents could not show any document on their behalf. Your lordship, thereafter, your lordship, I have repeatedly approached the municipality authority as to what is the status of that proceeding, what is the conclusion that they have come to, but we have not been informed of anything, and the illegal construction is being carried out at a rapid pace, your lordship. There are extension of cantilevers, your lordship, and we are the adjacent plot holders just adjacent to the holding number 450, against which we have come before your lordship with this writ petition, your lordship.
Yes, you appear for the corporation. Who appears for the corporation?
I'm appearing, my lord.
Yes, Ms. Bhavan.
My lord, on the basis of the complaint, my lord, the officials of the South Damda municipality caused an inspection, my lord, on 11th April 2025, my lord, page 43. My lord, thereafter, on proceedings was initiated, my lord, and hearing was held on 28th April 2025. It was heard and adjourned, my lord. Lastly, my lord, the matter was heard on 30th June 2025, my lord. And my lord, the private respondent took adjournment, my lord. My lord, next hearing would be held, my lord, in the next board meeting. So, my lord, your lordship direction will be given to, my lord, conclude the proceedings within a specified period of time.
Lordship, if they have a sanction plan, they could have shown it on the very first day, your lordship. They do not have a
Hearing
sanction.
is going on, sir.
Lordship.
So wait.
Lordship.
on the next date of 27th July.
Next is 27 July.
27th July.
Take it down. The petition, the present writ petition is aggrieved by the inaction of the respondent authorities in taking any action against the illegal and unauthorized construction being undertaken at property number at DAG number 446 at Mauza
Satgachi. Lordship, holding number
Satgachi.
450.
At holding number
450.
DAG number 446, Mauza Soza, holding number 450, under BN and BLN and LRO of Barakpur, PS Lake Town, District 24, South Pargana. Full stop. At the instant, not Pargana, at the instance of private respondents. Full stop. Learned counsel for the petitioner submits that the private respondents are carrying out illegal and unauthorized construction without any sanctioned plan. Full stop. Based on the complaints of the petitioner, the respondent authority had held a hearing. Had issued first. You had issued what, Ms. Bowal?
Yes, my lord. Your lordship can see page 43. My lord, the Southern municipality caused an inspection, my lord, on 11th April.
Based on the complaint of the petitioner, inspection, the respondent municipality had carried out an inspection on 9/4/2025.
11th April.
11th April 2025.
After on 28th April 2025, the proceeding was initiated and the my lord matter was heard.
And subsequently, the parties were directed to appear before the concerned executive engineer on 28th April 2025. Full stop. The proceedings are still underway before the executive engineer,
Before the board of councillors.
before the board of councillor,
Executive engineer.
before the board of councillor. The proceedings are still underway before the board of councillors, and the next date for hearing is scheduled for
27th July.
27th of July 2025. Full stop. Since the respondent municipality is already seized of the matter and is carrying out the hearing to ascertain the facts of the complaint as alleged, to the facts of the unauthorized and illegal construction as alleged by the petitioner. They are the full stop. The corporation is directed to conclude the hearing as expeditiously as possible, preferably within a period of 8 weeks, within a period of 8 weeks, and pass a reasoned and speaking order. Full stop. By way of a reasoned and speaking order. Full stop. With the above direction, the present
Not
petition
only
is
one thing.
disposed.
ABDBT in opposition has not been used for the allegation made by the petitioner
Yes,
PD9.
that goes without saying. So.
Lordship, if I may prefer an indulgence until the decision is passed, your lordship, if there can be a stop work, your lordship.
No stop. Affidavit of service taken under seized of the matter, seized of the matter, and the same is being heard by the seized of the matter, and the hearings are underway as alleged by the petitioner. Yes.
My lord, this has come up at my instance. My lord, I sought for leave on the last Friday.
Yes.
I have a sanction plan in respect of a G+4 storied structure. My lord, as
There's another petition also connected
in this petition
for the same property on the appellate side, on the original side. The call for the file of this.
but I have no knowledge of this. Are কোনো writ petition?
My lord, just now I have
Filed by the
received the
builder.
book, received
But
the
the
brief,
builder-
so I have no
Definitely
instruction.
takes a both together. My lord.
Tag together.
Take down. Just take down. There's another petition which has been filed by
Like demolition is running on.
Yes, my lord.
Demolition is
That was my
running.
urgency. My lord.
there's another petition which has been filed, another writ petition, WPO number 474 of 2025, titled Munna Mandal versus KMC, is also said to be connected with the present writ petition. Let both the matters be tagged along. Full stop. List on. We'll have it, when do you want, tomorrow?
Tomorrow.
No matter.
My lord, it will appear in the appellate side list. My lord.
It will appear in the appellate side list, my lord.
We'll call for the appellate side. We'll have it tomorrow.
My lord, in the appellate side. My lord.
Yes.
But I appear for the petitioner, the connected matter.
In the connected matter, see, there he comes.
And I was just saying for withdrawal of that.
Huh?
Withdrawal of that petition.
Withdrawal of that.
Withdrawal of
So
that.
you have to move an application tomorrow.
To move an application.
I shall.
But my service may be taken on record because I have served the.
Mr. We'll have it tomorrow. You keep your service, affidavit of service. Tomorrow we'll hear it. You are appearing for the corporation.
Yes, my lord. Let
Tomorrow.
Mr. Barin manage.
Tomorrow we'll have it.
Right.
Tomorrow, not today. नहीं ये order करेंगे, ये वाला तो order होगा ना, calling for the file. हाँ, order करा वो same order.
Not 5 minutes. I am for the appearing on behalf of the petitioner. But this is an application for recalling the order passed by the Honorable Justice Kaushik Chandra. This is my affidavit of service.
Yeah, restoration application or
No,
No,
it's
Lord,
just
it
a
is
recalling.
recalling of an order, Lordship, passed by the Honorable Justice Kaushik Chandra, Lordship. Lordship, the matter should be heard by his Lordship because is his order, Lordship. So order is at page 35, Lordship. I am for the Lordship respondent in this application, can application and writ petition in the writ petitioner in the writ petition, Lordship.
I am for the
Page with the
Page
application.
35, Lordship, and the
application. Of the CAN application?
yes, of the CAN application. And in the page 37, your Lordship will find that the order has been passed by Honorable Justice Kaushik Chandra.
হ্যাঁ
ঠিক আছে
ওটাই তো ওটা কেন দেখছি ওটা কেন না
প্যান্টটা ট্যাগ হয় Now, what is the rule here?
Lordship, that REIT is disposed of, Lordship,
It's a
by this order.
the recall application. वही होगा। The let this matter be since the petitioner has preferred a recalling application of an order dated. What is the date of the order?
13 June 2000.
10th March.
10th March
10th
2025.
10th March 2025, passed by a coordinate bench of this court. Passed by Honorable Justice Kaushik Chandra
it's a applicant হবে তো
in WPA number 30132 of 2024. Full stop. Let this matter be listed before the same bench, subject to orders of the Honorable Chief Justice. That is the procedure.
yes Lordship, only prayer is that, Lordship, that they are the applicant herein and respondent in the writ petition. We are the petitioner in the writ petition, Lordship.
Whatever it is.
Lordship, as a mentioned as a petitioner, that's
This is
The application filed by the petitioner only.
yes, yes. Grateful.
applicant, I mean that others.
The petitioner.
Grateful.
Maybe কি হলো
ইয়ে করে দিচ্ছি
রিলিজ ঠিক আছে রিলিজ করেছে release from this list.
Sorry?
Release regular.
Yes, regular bench.
Lord, my application, Lord, for
I appear on
recalling.
behalf of the writ petitioner, my lord, Mr. Siddhartha Banerjee, learned counsel, is leading me on his legs. Was humbly praying, lordship kindly takes it up tomorrow.
Tomorrow? You're sure? Tomorrow থাকতে পারবে দাদা নেই কিন্তু এই তো
My lord, on Wednesday, if your lordship permits.
Lord, my application for recall of your lordship's order, my lord, dated 2nd of April. Lord, Mr. Banerjee is in difficulty, my lord, kindly takes it up on Wednesday, my lord, in that case. Thursday নেই
Not today.
Wednesday আছে, Thursday নেই Grateful. Grateful.
অর্ডারটা দেখ অর্ডারটা হাতে রেখে দেখ কি বলছি Affidavit in opposition, Mr. Ghosh.
So, you know, directed possibly the report. Report was directed to me long back, my lord. The direction was there. The report, my lord, possibly, I'm not sure about the evidence opposition of the report.
Let me see the order.
And the report, my lord, so far as the report is concerned, my lord.
Report.
I'm seeking, my lord, another opportunity because the engineers in the position are no longer, my lord, in that department right now. They have already been transferred. I inquired of their, my lord. The other persons, my lord, who are in the position, they are, my lord, locating the file and, my lord, they are. Asked for today, they will meet me.
They have taken such a drastic step, as a result of which I am not able to, my lord, it is tantamount to blacklisting. And 1 year back, rather.
Last opportunity.
That's
How much time? Learned counsel for the respondent KMC, Mr. Alok Kumar Ghosh, seeks and is granted one last opportunity to file his report by way of an affidavit. Exception to the same, if any, within 1 week thereafter, list after 4 weeks, after 4 weeks.
a date may kindly be fixed, my lord, since the question of my avocation.
4 weeks. After 4 weeks, we have a date. 4th August.
Lord.
Sir, please. To watch your videos, go outside and watch your videos. Let us do some serious business here in the court.
যা হয় অডিওটা অন করা হয় অফ করাছি হয়নি Wait, please, Your Lordship, my lord. My allegation of unauthorized construction on last occasion, my lord, directed, my lord, corporation wanted to, my lord, be better acquainted about the, my lord, information regarding the position of the matter, my lord, whether it is, because the private respondent statement is that it is already regularized. But I do not have any information.
Good for the municipality.
Corporation.
Yes, my lord, I happy for the corporation. Now, my lord, the instructions that my lord, my junior has received is that, my lord, after the allegation of the unauthorized construction has made, my lord, as per the law, it went before the special officer building under section 400. Now, my lord, the special officer building under section 400, after
Yes.
my lord, having considered as passed an order regularizing it, holding that it is not to that extent of a major construction that is to be demolished.
You challenge that order?
My lord, may I get a copy?
Of course, indeed.
My lord.
Learned counsel for the petitioner seeks to withdraw the present writ petition to avail his remedies in law. The present writ petition is dismissed as withdrawn.
Kindly record only one sentence that the statement, it is the instruction of the KMC that it has already been regularized. That is why, my lord, I am online.
Learned counsel for the petitioner seeks to withdraw the present writ petition in view of the fact that the property in which the illegal and unauthorized construction is alleged to have been regularized by the Calcutta Municipal Corporation by order dated. By order dated
17th March 2025.
17th March 2025. Full stop. The petitioner, in view of the said development, learned counsel petitioner does not wish to present does not wish to press the present writ petition. The same is dismissed as withdrawn.
15th March is post filing of the writ petition.
Whatever it is.
MD close.
Obligation.
My lord, lordship fixed the matter on Friday, my lord. Somehow it was came on the list.
We'll have it on Friday. By mistake, it has come today.
No
problem. We'll have it on
Friday.
We'll have it on Friday.
Oh, next matter.
That's it.
Lordship, the 11, I am for the petitioners. Lordship, this is my affidavit of sign. Lordship, petitioners are the unemployed youth. Now, Lordship, the concerned municipality, that is the Jhalda municipality, Lordship, the offered the Lordship the petitioner that the sum of the rooms of a building would be given as a
Yes.
Lordship, the concerned Jhalda municipality,
Yes.
Lordship, the offered these petitioners who are the unemployed youth to take on rent of some shop rooms to run their business. Now, lots of the petitioners, all these petitioners in the year 1995 to 2005, all have been, lease deed has been executed between the parties that they will run the business as per the enlistment lordship trade license of the concerned municipality. Lordship, regularly we are paying the lease rate. Up to March 2025, they have accepted the lease rate. All on a sudden, invoking section 223 without giving any so cause, even without giving any lordship the intimation and lordship the any notice of inspection, invoking section 223, lordship the concerned executive officer of the concerned municipality issued a notice of eviction that the building is dilapidated. So lordship, the building has to be demolished. So you vacate this building. Lordship, this is the notice. Lordship, kindly come section 223 of the West Bengal Municipal Act. Lordship, there is a book.
1993.
1983. Lordship, section 223, Lordship, got it. Power to order demolition of buildings dangerous, ruinous, or unfit for human habitation.
Yes.
Where the Board of Councillors, upon any information in its possession, is satisfied that any building is unfit for the human habitation and is not capable at the reasonable expense of being rendered fit, it shall be served upon the owner of the building and upon any other person having an interest in the building. So let's say petitioner have the interest in the building, whether as lessee, mortgagee, or otherwise, a notice to show cause within such time as may be specified in the notice as to why the order of demolition of the building should not be made. So let's say there is a provision of issuance of show cause notice. Kindly come subsection 2. If any of the persons upon whom a notice has been served under subsection 1 appears in pursuance thereof before the Board of Councillors and gives an undertaking that such persons shall within a period specified by the Board of Councillors execute such work of improvement in relation to the building as will, in the opinion of the Board of Councillors, rendered the building fit for human habitation, or that a building is not to be used for human habitation until the Board of Councillors, on being satisfied that it has been rendered fit for human habitation, cancel the undertaking, the Board of Councillors shall not make any order of demolition of the building. Lordship, there is a provision of natural justice. Lordship, nothing has been, here is also nothing has been done. No notice, no so-called straightway. Lordship, they have issued notice of eviction. Kindly come 3. If no such undertaking as is referred in subsection 2 is given, or if in a case where any such undertaking has been given, any work of improvement to which the undertaking relates to and carried out within the specific period, the building is used in contravention of the terms of the undertaking, Board of Councillors forthwith makes an order demolition of the building, requiring that the building shall be vacated within such period not less than 60 days from the date of order, as may be specified in the order, and the demolition within the 90 days after the expiration of the period. Now, Lordship, kindly come subsection 4. Where an order of demolition of the building under this section has been made, the owner of the building or any person having an interest shall demolish the building within the period specified in the owner. Lordship, this is not, time has come. Now, Board of Councillor also cannot be, Lordship, this is the situation. 1, 2, 3, Lordship, nothing has been complied with. Now, Lordship, the kindly come the lease deed, lease agreement, that is page 26 of my writ petition. It was executed in 1998.
5 years. Clause 6, 5 years is one term. Clause 6, 5 years.
Lordship, please turn page 28. The measurement of the building, 8 inch by 10 inch.
My system. যেটা দোকান ঘর, shop.
Yes, my shop room is 8 inch by 10 inch. Now, Lordship, these are the lease deeds, respective lease deeds of the petitioner. Now, kindly come, page 32 is the certificate, Lordship, the permanent certificate of enlistment.
No. 2025.
Yes. Now, Lordship, kindly come. It is valid up to the last paragraph, last but second paragraph, Lordship, 17 June 2025. It was valid. Now, Lordship, these are the all certificate of enlistment. Kindly come, my payment of rent, that is page 41. Lordship, kindly come, this is the date, April 24 to March 25. Up to March 25, we have cleared the rent in favor of Jhalda municipality. And prior to the, Lordship, the payment of, let's say, expiry of the payment of rent, because now we are agreed to pay the entire rent, whatever the current rent is. Page 44, Lordship, this is in vernacular language, Lordship. The 3rd August 2024, this notice was issued. According to the, Lordship, the condition of the notice that Ramkrishna Mahato Government Engineering College, Lordship, declared the building as a dangerous. Now, it has been noted that any time building can be demolished. So, Lordship, as per the report of Ramkrishna Mahato Government Engineering College, Purulia report, Lordship, Board of Councillor by a resolution dated 3rd August 2024 has taken the resolution that this building is dangerous and any time, Lordship, the accident can be happen, and invoking section 223 directed that to immediately remove this, hand over the possession of the building. So, Lordship, first of all, let's say so cause notice has been given. Lordship, there is a provision of maintaining the natural justice. Lordship, the no inspection report has been handed over. Even we have not dealt with the, Lordship, the inspection report, whatever the PPR. Now, Lordship, what is the reason behind them of issuing the notice? The reason behind them issuing the notice, the Lordship, this is my specific case in the writ petition. I have, Lordship, pleaded in the writ petition that building is not a dangerous building. Now the body is changed. Due to changing of the body, they somehow have tried to evict us from my, Lordship, the livelihood, which has continuing from since 95 to 98, 95. So, Lordship, for this reason, I'm praying for, let this impugned eviction order be stayed, and whatever the report, Lordship, my learned friend is wish to fight, Lordship, kindly for the time being, let this interim order be stayed.
Yes, sir.
Lordship, let us first come to page number 44, which is the notice.
Yes.
The notice only says that the building was surveyed by this Ramkrishna Mahato Government Engineering College,
Yes.
and they found this building to be in a very bad condition. This is the
passed an order under section 223.
There is no order, Your Lordship. If I
Let's read Dhara. Wait a minute. The West Bengal Municipal Corporation Act 223 Dhara. You
This
read
is-
it.
this
My
is-
Bengali is not that good. So
Lordship, I'm reading.
Lordship is
আপনার অবগতির জন্য জানানো যাইতেছে যে পৌরসভার পূর্ব প্রান্তের পুরাতন সমগ্র বাণিজ্যিক ভবনটি রামকৃষ্ণ মাহাতো গভর্নমেন্ট ইঞ্জিনিয়ারিং কলেজ পুরুলিয়া হইতে বিপজ্জনক বলিয়া ঘোষণা করা হইয়াছে। উক্ত বিল্ডিংটি যে কোনো মুহূর্তে ভেঙে পড়ার আশঙ্কা রহিয়াছে এবং প্রাণহানি ও সম্পদের প্রচুর ক্ষয়ক্ষতি হইতে পারে। উক্ত বাণিজ্যিক ভবনটি উপরোক্ত স্টল নম্বর এর দোকানে আপনি পৌরসভা হইতে ভাড়াতে অদ্যাবধি ব্যবসা করিতেছেন। রামকৃষ্ণ মাহাতো গভর্নমেন্ট ইঞ্জিনিয়ারিং কলেজ পুরুলিয়া রিপোর্ট পরিপ্রেক্ষিতে ঝালদা পৌরসভার বোর্ড অফ কাউন্সিলরের ইংরেজি 3/8/2024 তারিখে মিটিং এর উক্ত বাণিজ্যিক ভবনটি বিপজ্জনক বলিয়া অতি সত্বর খালি করার সিদ্ধান্ত গৃহীত হইল। যাহাতে কোনরূপ প্রাণহানি ও ক্ষয়ক্ষতি না হয়, তাই আপনাকে অতি সত্বর আপনাকে দোকান ঘরটি খালি করার নির্দেশ জারি করা হইতেছে। Already lordship
Dangerous.
It is only a notice which says
See, it says
that the building
dangerous.
that
This
the
is
building
dangerous.
is a dangerous condition.
dangerous.
You are advised to leave the premises and as per section 223, you give us a
As far
reply.
as section 223 is concerned,
They have replied to it, your lordship.
sir, you are supposed to give them a notice before you pass an order.
There is no order. There is no order.
Notice is what?
This is only a request to leave the premises as because the building is in a dilapidated
Before you
condition.
declare a building to be dilapidated, you have to follow the due process of law, which is to notify the owner or any other person who has interest in the building, and then you have to proceed.
Now, your lordship,
Where is that?
your lordship, since
Just
2016,
because you bring in some private engineering college, they will decide the building to be dangerous.
lordship, since 2016,
Yes.
there have been certain applications made to us wherein they have stated that the building is in a dilapidated condition.
Very good.
And these applications were made by the stall owners. Now, when upon receipt of these applications, we made certain repairs. After a certain period of time, when they left the premises, then we had conducted a survey through this engineering college, and they told us that this building is in a dilapidated condition. It is in a ruinous condition, so it is better. So in order to ensure that there is no threat to the life and property of any party, first remove the persons who are there. Then we will seek whatever, and your lordship, we will always give privilege to the persons who are already rightfully there.
You have to.
There is no problem. Now, your lordship, if you kindly comes to page number 47, that is their reply. On the page number 48, they have themselves said, for the market complex and stall number stands on the ground floor is my leasehold property, and it is safe and not damaged at all. If the stall of the first floor needs minor repairs, it can be repaired by the municipality, for which the dismantling is not required. So they have in a way accepted that there is certain repair which is required. Now they are not.
There's a huge difference between a dilapidated building and a minor repair,
Lordship,
sir.
this is being written by the petitioners. So they are only worried that their possession will go. But that is not the case. If this building falls apart, who will be responsible? Kindly ask them to give an undertaking that we will not be responsible. If something happens,
so give them a notice. You have to follow the due process of law. How can
this is the notice we see, lordship. This notice is of August 2024. They have filed this writ petition in November 2024. We have not done anything. We have only asked them. See, this letter is only a precautionary measure from our part, only to make them aware that this building is in a dilapidated condition. So it is better for them only. At this point of time, as far as my information goes,
Yes.
all the other people have left because they all know that.
Have you given them a copy of this structural engineer's report?
They have not even sought for that in their reply. If your lordship,
you are supposed to give it to them.
Your lordship, if you direct me, I will within 2 days I will supply it to them. Not only that, your lordship, if your lordship feels that any other party, any other body should go and
report, give them the hearing, and then take a reasoned decision on it.
Much obliged, your lordship. Much obliged.
Take down. The petitioner has preferred the present writ petition being aggrieved by the impugned memo bearing number 206/21/DM dated 3/8/2024 issued by the executive officer, Jalda Municipality, full stop. By the said memo, the petitioners who are lessee of stalls situated in Block N, Jalda municipality, were directed to vacate their respective premises on the ground that the building in question has been declared dangerous, and unfit for human habitation by the Ramkrishna Mehto Engineering, Ramkrishna Mehto Government Engineering College, Purulia. Full stop. Relying on the said report, the Board of Councillors, exercising powers under Section 223 of the West Bengal Municipal Act 1993, resolved to vacate the building to prevent any threat to life or bodily harm of any of the occupants. Full stop. The petitioner contend that they are lawful lessee in respect of municipal stall number. Yours is 04, right?
410-6.
410-6, para 4.
Para 4, page 6.
It's respondent 004, that's page 28, block N, room number 4.
410-6.
410 and 6.
Block N.
Block stall number 404, 06 and 10 of block N. Under valid lease agreement executed in the year 1998, and the petitioners have been paying monthly, been paying rent without any default. Full stop. According to them, the impugned notice has been issued abruptly and without following the due process mandated under section 223 of the West Bengal Municipal Act 1993. Full stop. They further submit that they were neither individually notified nor provided with any opportunity of hearing to the before the issuance of the impugned memo dated 3/8/2024. Full stop. It is learned counsel for the petitioner states that it is a specific case that the structural condition of the building is not as precarious as has been as projected by the respondent municipality. Full stop. They assert that the report of the Ramkrishna Mehto Government Engineering College, Purulia, which forms part of the impugned action, has not been furnished to them. Full stop. The petitioner also allege that the impugned notice has been issued without impugned notice is vague, general in nature, and does not specify any timeline for demolition or making provision for their rehabilitation, which is essential considering their long-standing lease deed. Full stop. Learned counsel for the respondent states that the petitioner has replied to the said notice, and what is your submission?
They have themselves agreed that there needs certain repairs
and have admitted to some minor repairs in the building, though the counsel for the respondent, Jalda municipality is unable to show the compliance with section 223 before declaring any building to be dangerous, building to be demolished for being dangerous, ruinous, or unfit for human habitation. Full stop. A bare perusal of the impugned memo dated 3/8/2024 reveals that it is a general notice addressed to all the occupants of the building and does not comply with the requirement of issuance of individual notices to the affected habitants of the building. Full stop. The petitioners were deprived of their right to respond to the specific allegations regarding the condition of the premises being declared to be dangerous, thereby violating the principles of natural justice. Full stop. A conjoint reading of section 223 of the West Bengal Municipal Act 1993 reveals that before the building can be declared dangerous or unfit for occupation, the municipality is required to follow certain procedural safeguards, including proper inspection, communication of the finding to the affected parties, and grant an opportunity of being heard. Full stop. In the present case, none of these procedural steps appear to have been followed by the municipality before issuance of the impugned memo dated 3/8/2024. Full stop. The non-disclosure of the expert's report, the absence of individual notices, and failure to provide an opportunity of hearing to the petitioners render the impugned memo legally unsustainable. Full stop. The petitioners, in the light of the above observation and for violation of the principles of natural justice, the impugned memo dated 3/8/2024 is hereby quashed and set aside. Full stop. The respondents are directed to 1. Furnish a copy of the structural inspection report prepared by the Ramkrishnan Mehto Government Engineering College, Purulia, within a period of 1 week. Within 1 week from the date of communication of this order. Full stop. Second, the petitioners shall be granted a personal hearing within
4 weeks.
Within 4 weeks thereafter. Full stop. Third, a reasoned speaking order upon due consideration of petitioners' submissions shall be passed within a period of
4 weeks from date of hearing.
4 weeks thereafter. Full stop. Full stop. It is made clear that this court has not expressed any opinion on the merit of the structural integrity of the building, and all the contentions are left open to be decided by the competent authority in accordance with law. Full stop. With the above direction, the present writ petition is disposed of.
Actually, put it two things. That is, we had served notice on each of the occupants. That is one. And second is, your lordship, in the meantime, if something happens, we may not be held responsible. Because we had.
So that is the reason you shut down the, you cut short the period, we'll do it. You have asked for 4 weeks, let's do it in 2 weeks' time.
I did not get any instruction, that is why I placed for.
So we can cut short the duration. 1 week for structural stability report. Next 2 weeks, you decide their representation. And within a week, you pass an order. Ye kar do. 1 week for structural stability, 2 weeks to decide the hearing, and 1 week thereafter pass the reasoned order. We'll cut short it. Get affidavit of services taken on record.
My lord, I am representing state in this matter.
12, my lord, I beg to appear on behalf of the petitioner.
In this matter, my lord, I was directed to cause an inspection at the premises at the instance of the court. My lord, I have done that, prepared the report, but my lord, may I seek apology, my lord? I do not find copies of the reports to serve. May I come back tomorrow, or your lordship can go through the report? I can circulate. Yes, yes.
At 13 November, the matter was moved when the court directed us to give a report by on our part the extent of unauthorized construction. Next, my lord, 21st of November, matter came, my lord, when I reported to the court with a report that the extent of unauthorized construction more than 5,000 square foot. Then the court, my lord, they sought to say that it is not so much of unauthorized construction. Then the court asked directed my learned friend appointed to ascertain the extent of unauthorized construction, because the 2 more floors, my lord, in addition. But I will give to the report that this is the extent of unauthorized construction they are making. Let us see, my lord, what the special officer has come with the report.
But subject to correction, my lord, the similar matter, lordship is, my lord, directed them to file report and to take exception on all this. 400 subsection 8 matter. If it is permissible under the, my lord, if this honorable court kindly thinks it fit and proper, to tag this matter with that matter, because the main argument.
G+2, G+4 story building has been raised. They cannot get any intelligence on the basis of that law, this and that is saying.
Well, KMC on the one hand, my lord, regularizing.
Give them a copy.
Yes. Well, in course of the day.
Learned counsel.
At a party. I am using a passport of that building. That is passport I may be affected. For that reason, I file an application. Can do for addition of party.
Can do is on record. Who are you?
Honorable person. Well, I am the one of the owner in the that in question. I am using a passport of that property in question, which is within the permissible limit, and the building plan sanction up to G+2 is set.
You have served a copy to everyone?
No, yet to receive any call.
I have an instruction from the concerned PS mallet, which says that 201 notice has been issued by the corporation mallet and intimation has been given to the PS. Thereafter, mallet, the construction has been regularized mallet. Thereafter, no complaint has been given by the corporation.
My lord, lordship knows, my lord, 401 is the preparatory work of corporation to be initiated. Stop work. Then, my lord, the matter to be placed before the special officer building for adjudication. One appellate forum is also there. I will show, my lord. I will show the judgment.
You will show all the.
We'll allow his application.
Yes, my lord.
Just take down. Can do. Petitioner has preferred the present writ petition seeking addition, seeking improvement in the present writ petition. It is the case of the petitioner that he is the owner of a flat at premises number 10 Gopal Biswas Lane, Post Office Sham Bazaar, Police Station Sham Kukar. The subject property in dispute in the present writ petition. Full stop. which is the subject property in dispute in the present writ petition. Full stop. In view of the reason stated in the application and that the petitioner is a occupant of the premises which is under dispute in the present writ petition. The present application is allowed. Petitioner is made a necessary party to the present writ petition. Petition is added as a necessary party to the present writ petition. Full stop. You carry out the
Necessary amendment.
learned counsel for the petitioner.
A copy is required for the purpose.
Petitioner is added as a respondent to the present writ petition. The petitioner shall carry out the necessary formalities in terms of adding the.
Lord, copy of application is needed, my lord, to undertake necessary.
Give a copy of the application. To add petition in can 2 as a respondent, as a party respondent to the present writ petition. Full stop. Then learned counsel for the special commissioner.
Special officer.
Special officer states that the seeks and is granted 1 week time.
What is the
No, I can serve it by today itself.
Seeks and is granted 1 week. 1 week time to file his report. Full stop. Exception to the same, if any, within
7
2
days or
weeks.
10 days. 2 weeks, my lord.
Is there a stay or what?
Yes.
That's why you are asking to.
He is asking therefore.
My lord, we have to face this honorable court.
All right. So, special officer shall be, learned counsel for the special officer has filed a report with the same is taken on record. Full stop. Learned counsel for the petitioner states that seeks and is granted 1 week time to file his exception to the said report. List after 10 days.
Only, my lord, the stay is required to be extended, my lord, subject to lordship pleasure.
Already, my lord, expired.
Already expired.
Already expired. They are not doing anything. We'll have it next week. 10 days, sir. After 10 days, give a date.
My lord.
Deeply obliged.
18th? 18th, we'll finish it.
Lords. Destined to suffer, my lord.
Can 2 is disposed of it.
Can is disposed of.
Lordship, I am for the respondent number 8, private.
Yes.
For the petitioner lordship, respondent number 7 died. This came to knowledge of the petitioner during the pendency of writ petition. So I'm praying for 4-week adjournment for to come on record hears of the respondent.
Lordship, petition number 7, the respondent number 7 and 8 are brothers, and they are the resident and original owners of the premises at the moment. Now, I am for the respondent number 8. Respondent number 8 and 7 have inherited this ancestral property and they have been occupying this since the time of birth, Your Lordship. The petitioner here is the owner of a shop space which is within the premises and is within the boundaries of the original structure that is there. Now, in due course, post inheritance, there has been so basically whatever information has been placed here has been altered as per the convenience of the petitioner to suit their needs. There are multiple civil suits pending which have not been incorporated here. The shop space which is in concern was on the northern side of the eldest brother who had sold it off to the petitioner's brother. The petitioner here is a tenant as placed here. Now, this particular shop space, there were 2 individual walls and a separation between the main building and the shop space. Now, that particular, to further enhance the space between the in the shop, they have attached the shop to the main building, and there has been subsequent damages. They have raised allegations that I have made illegal construction to which they could not justify and place any documentation. There are whatever altercations have been made, we have sustained and we have proper sanction plan to justify our statements here. Also, when it comes to petition number 8, Lordship, this is an old ancestral property located in the suburban areas.
Are you carrying out any construction?
Lordship, no, there has been no altercations or structural changes that have been made to the respondent number 8's portion of the property. Whatever changes that have been made are internal, perhaps a door that has been replaced or whatever repair work has been constructed. The superstructure
Who's for the
remains at
respondent?
original. Now, respondent number,
Corporation? Which corporation is this?
this is Boshirhat Municipality, Lordship.
Have you supplied them? Served them a copy?
No.
What? No.
I don't have any instruction,
Lordship,
Lordship.
this is a new motion. There has been service made. We have received
I
copies.
don't have any
You are appearing for whom, madam? For the petitioner?
petitioner. My senior is
Yes.
there.
Where is your senior?
He's not in the court, my lord.
What are your instructions?
Just I'm praying for 4-week adjournment to bring on record hears of the respondent number 7. Respondent number 7 died.
4 weeks, nobody gives you adjournment for 4 weeks.
Lordship,
So
for
at least 2 weeks.
representation for
Time at
for
least
respondent
2
number
weeks.
7, respondent number 9 is the son of the respondent number 7. They have so the respondent number 7 post his demise has left 2 legal heirs. They've incorporated the respondent number 9 here.
Not today. Not today.
Lordship, Lordship, just seeking indulgence, Lordship. This is whatever documentation. If Lordship could find pass on.
You'll see it. She's not able to assist. Not today.
Get food.
We'll come back after 5 minutes.
Hello. Hello.
14.
Instructions to appear on behalf of KMC, Kolkata Municipal Corporation.
Who's for the petition, madam? What is their unauthorized construction?
I do not have instruction at present, my lord. I have been briefed just.
Oh, you have the brief.
My lord, petition has not yet been served.
Must have settled it. That's why no one is there. Dismiss the default. None for the petitioner. Present petition.
At 15, my lord, I am praying for short Passover. I am for the respondent number 345. So Shaunak Ghosh is appearing. He is in another courtroom.
I'm appealing to the corporation.
Where's your counsel?
He is in another courtroom now.
Tomorrow? Not today.
I appear for private respondent number 3.
And 69 for the petition.
Lord, I am appealing for the municipality, my lord.
Not kindly
Appear
take,
for the private respondent.
kindly takes up page 29 and we 29. And we made a RTI application before the municipality and seeking details of the sanction plan of the building that is being constructed. And the next page is the reply. And clause 4 is important, page 30. And the said building plan, the municipality says the said building plan was sanctioned for 4-story building. And this is on 22nd of February 2024. And then we made representations starting from page 31. We filed this writ petition because this building was being constructed for 7 floors. After the writ petition is served upon the municipality, that they without any further representation in the RTI Acts, they supply another information on 29th of 11th, which I have made a supplementary affidavit. And may I file the supplementary?
What is it? Tell me.
And they say that the sanction plan is for 7 stories. After we serve a copy. And the thing is, the road width that is there in the location, it is 3.6 meters. As per the rules, the building height cannot exceed that much. And I have the rules.
Who are you?
And I am the adjacent flat owners.
Flat owners. So what is your problem?
That the construction is being made illegally. That is first. The second, is that it is in the vicinity of the airport. That is the
So your writ petition goes to that extent that there's a sanctioned building plan. Challenge the plan. Go and challenge the plan.
I am led by.
The sanction was for 4-story building.
Sanction is for a 7-story building. You have knowledge of it now. Challenge the sanction plan.
Blood, they have replied in my application.
Forget it, sir. I'll deal with that. I'll dismiss it.
Blood, then blood kindly grants us liberty. Or blood, we don't have that sanction plan. Blood, let them produce that sanction plan. We can challenge
Get
it.
whatever sanction plan you have to get. Challenge the sanction plan. Withdraw this writ petition. Challenge the sanction plan.
Blood, may I get a copy of that? Blood, I don't have. Blood, if I want to challenge it,
File RTI. Get a copy.
blood, RTI I have applied for.
So
Blood, in reply,
wait for it when you get. Wait for it till you get the.
blood, they have replied. They have replied saying,
Sir, after that, the RTI which you had filed another RTI. They have a 7-floor sanction plan. Get the plan from the corporation under the RTI Act. We are not here to provide you sanction plans. All right.
let me grant us liberty to challenge that sanction.
Already have the liberty in law. Learned counsel for the petitioner seeks to withdraw the present writ petition.
Or may I seek one more line?
Avail
That if I apply for an
as applicable in law.
if I apply for a copy, they will provide us.
No, we are not sitting here as an RTI court. Affidavit of service taken on record.
By the last order passed by Honorable Justice Kaushik Chandra, the respondent municipality had.
Yes. All right. Give the file. Wait a minute. Let me dismiss it.
In view of the subsequent
17
देना
16টা হচ্ছে
affidavit service taken on record. Petitioner has just a minute. Petitioner has preferred the present writ petition being agreed by the inaction of the respondent municipality in not taking any action against the unauthorized construction, against the alleged unauthorized construction carried out with the respond number 3 at holding number 344 MC Garden Road, Calcutta, Ward 14. Full stop. The petitioners are residents of Ondrilla apartment situated at 38A/4 Mahendra Chandra Garden Road, Calcutta. Full stop. Sir, I'll dismiss with cost. I'll dismiss with cost. Because unnecessarily you're wasting my time.
Sir, I'm not really let.
Sir, I'm telling you, there's a sanction plan. Your writ petition is for the unauthorized construction. There's no unauthorized construction. You want to challenge the sanction plan? Challenge the sanction plan.
I'm relying on their document where they have said it is 4 stories.
Sir, that document is an outdated document. They have made a statement. There's a sanction plan. You are aware it's a 7-story. You're
But that
filing
is from the bar. That's the whole difficulty. Otherwise, I cannot challenge it anywhere. That's the whole difficulty. But if they come forward with a 1-line affidavit, I have no difficulty.
All right. All right. Ms. Bhoval, you're appearing in this matter. There's a sanction plan, Ms. Bhoval.
1-line affidavit, that disclosing that
There's
sanction
no
plan.
need, sir. Yes.
They have relied upon the RTI reply where it has been stated that 4-story building manner.
Yes.
And subsequently it has been modified manner.
All right.
And additional alteration plan has already been sanctioned for
All right. The
settlement.
petitioners are residents of Ondrilla apartment situated at 38A/4 Mahendra Chandra Garden Road, Calcutta. It is the submission of the learned counsel for the petitioner that the private respondent number 3 is carrying out illegal and unauthorized construction at the above mentioned site. Full stop. Learned counsel for the petitioner states that he had filed an RTI application on
This is on 15th February 2024.
On 14th of February 2024. On 15th of February 2024 before the South Dum Dum municipality. wherein he had sought information regarding the building plan, regarding whether there was regarding whether any building plan has been sanctioned, full stop. B, who had applied
And the number of
building
stories.
plan. A, B,
4, my lord. Item number 4, serial number 4.
sorry, petitioner. The petitioner had filed a RTI application dated 15 February 2024, where he had sought certain information, including the number of the number of stories which were proposed to be built in the sanction plan, full stop. South Dum Municipality, full stop. South Dum Municipality had replied by letter dated 22/2/2024, wherein it was stated that the building is sanctioned up to 4 stories, full stop. Learned counsel for the petitioner, full stop. Learned counsel for the petitioner is learned counsel for the respondent corporation appears and states that the present building learned counsel for the petitioner states that though the building was sanctioned only till the 4th floor, but the construction has been carried out till the 7th floor, full stop. Learned counsel for the petitioner is states that he is aware that the building plan was subsequently modified, and the respondent number 3 has got a sanction plan till 7 floors, 7th floor, 7 stories. Full stop. The said fact is corroborated by the statement of the learned counsel for the respondent, South Dum Municipality, who states on instruction that the building plan has been, who states on instruction and hands over her instruction, wherein it is stated that the building plan being 313 dated 4/12/2019 was sanctioned for 4 stories, and an addition alteration building plan being 520 dated 22/2022 was sanctioned for 7-story building. She states that as per the building plan, there is no addition of floors to the said building. The petitioner has filed the present writ petition. There is no merit in the contention of the petitioner in the present writ petition, since the building has been constructed in accordance with the sanctioned building plan, and that the petitioner's reliance on the RTI information is not sufficient to for preferring this writ petition, since the said information is not correct, and on the basis of the said information, the petitioner has preferred the present writ petition.
Rule 49 I have referred.
The petitioner has, give me a supplementary.
Rule 49, millet. And
Supplementary affidavit.
Oh, supplementary.
Though the petitioner has come up with a supplementary affidavit, wherein the petitioner is aware that the contents of the present writ petition are not correct, and he wants to file the
In
supplementary
violation of
affidavit,
Rule 49.
and he wants to rely on the supplementary affidavit which itself demonstrates that the building under consideration is sanctioned till seventh floor, full stop. In view of the said facts, the present writ petition is not maintainable. The petitioner has alleged unauthorized construction, which in terms of the sanctioned building plan is a valid construction being carried out by the respondent number 3 in accordance with the subsequent building plan number 520 of 2022, full stop. In view of the said fact, this court does not wish to exercise its discretionary jurisdiction under 226 of the Constitution. The present writ petition is dismissed. Full stop. Yes. Yes, what are you saying?
I was relying on Rule 49, that's all.
Relying on?
Rule 49, that the width of the road vis-a-vis the
Sir, you channel the sanction plan. The take down. The petitioner has preferred this writ petition knowing very well that the building was with a duly sanctioned plan up till 7th floor, but has preferred to conceal the said fact. This court notes that these kind of petitions are filed to harass and extort money from people who are carrying on construction in accordance with valid sanction plan. This court deprecates such filing of petitions. The present writ petition is dismissed with a cost of 10,000.
Your Lordship, in item number 17, Advocate Sushantopal is appearing for the private respondent. He is in court number 11, my lord. I'm praying for a short passover.
Where is he? Who are you? Private respondent?
Yes, my lord.
Yes, tell me. Lord, what is the issue? What is the issue, sir?
The private respondent, who is the sister of the petitioner, lodged a complaint before Bidhannagar Municipal Corporation that the underground reservoir, which was constructed and sanctioned in the year 1985, is not at the place where it should have been. That was the complaint. Bidhannagar Municipal Corporation issued a notice to me without giving me any opportunity to demolish the structure. I replied. Thereafter, they served a notice that on such and such date, there will be a hearing. You are requested to be present there. In the meeting, without any reason, without assigning any reason, it was ordered that the said underground reservoir is to be demolished by you. I challenged the said order before this learned court. On the date of hearing, when the order was passed, then demolition was being carried there. Telephonically, it was communicated to them that such and such order has been passed by this honorable court. Please stop construction, demolition of the said construction. But they said that as because we don't have any written order, I want to stop, I will complete the demolition. It was further mentioned before the court. The court passed an order on 3rd of December 2024.
Yes.
By that order, the honorable court ordered me to construct temporarily the said underground reservoir at my cost, and subsequently, if it is found that your petition is all right, that cost shall be reimbursed by them, or the court will take its own process. That is the order of third, and the court also directed them to file a compliance report. I hope they have their report today, Milord.
Look, so far as our contentions are, there is a building plan of this house. Admittedly, that is a sanctioned building plan. In that sanctioned building plan, the particular
Area where
the water reservoir is there is not designated. And accordingly, Milord, this is a feud between the two parties because they are staying there, Milord. If Milord will kindly take up page 56 of the writ petition, Milord, once. Milord, may I place the order? The instant proceeding is drawn up upon the receipt of a complaint dated 8th January 2024 by Gopa Bhaumik, one of the co-sharers residing in such and such, of an unauthorized relocation of water pump on the first floor of such and such by her brother being one of the co-sharers, namely the Abhijit Das. Milord, Abhijit Das is the petitioner here, and Gopa is, Milord, the private respondent. Allegedly, which was earlier situated at the ground floor of the subject premises, which caused seepage of water in one of her bedroom and damage of the ceiling of the ground floor. She also alleged unauthorized shifting of reservoir from front side to back side of the premises by Abhijit Das. On the basis of the complaint, physical inspection was conducted on 15th January 2024 by the officials of the Bidhannagar Municipal Corporation at the subject premises. At the time of inspection, it was noticed that the groundwater reservoir was shifted from the front to back side of the building, which is totally beyond the last sanctioned building plan. Ground floor is rented out, ground floor back is under Gopa Bhaumik, and first floor fully occupied by Abhijit Das. Subsequently, Vide such and such executive engineer building plan, Bidhannagar Municipal Corporation issued a notice upon the residents of the subject premises, namely Srimati Archana Das, Sri Abhijit Das, and Srimati Gopa Bhaumik. Milord, Srimati Archana Das is the mother of the brother in the system. Yes, ma'am. To demolish the unauthorized water reservoir at the back side and reconstruct the same as per the location shown in last approved sanctioned building plan within 4 weeks from the date of issuance of this letter, and to furnish a compliance report to that effect, failing which recourse as per the West Bengal Municipal Corporation Act will be taken up. The authority at the BMC received 2 responses after issuance of the above notice. By means of letter dated 21st March 2024 through Advocate Anish Das, on behalf of his clients, namely Srimati Archana Das and Sri Abhijit Das, they vehemently opposed the notice issued by BMC. However, the complainant Gopa Bhaumik is by means of a letter dated 22nd March 2024, in response to the notice issued by BMC, informed the corporation authority that admittedly the unauthorized shifting of groundwater reservoir was done, and despite her best efforts, due to non-cooperation by another co-sharer, Shri Abhijit Das, she is unable to carry out the directions given by the corporation. She also informed that she is put under threat and may suffer dire consequences by her co-sharer, Shri Abhijit Das. Subsequently, notice of hearing was issued by the corporation Vide such and such for a hearing scheduled on 13th April 2024. At the time of hearing on 13th April 2024, the following persons were present: Gopa Bhaumik, Sharola Kumar Bhaumik, Abhijit Das. At the time of hearing, Abhijit Das submitted that he is duly authorized to submit and appear on behalf of Srimati Archana Das, his mother, in respect of the subject premises. He submitted that shifting of the water reservoir from front to back side and the pump from the ground floor to the first floor was done by the original lessee, being his father, late Ranjit Kumar Das. He also submitted that tax is paid by of the total holding of the subject premises. There is no pump at the ground floor, and the pump in the first floor is also installed by the original lessee, that is their deceased father. However, it is admitted by him to the shifting of the ground floor reservoir by the original lessee, that is his father, which is beyond the last approved sanction building plan, which is requested to be regularized by the authority at BMC. Srimati Gopa Bhaumik submitted that she cannot say as to who shifted the ground floor reservoir, whether her father, the original lessee, or her brother, Sri Abhijit Das. However, she demanded that the position of the ground floor water reservoir be restored to its formal position as per the last approved plan. Under the facts and circumstances, the undersigned did such and such. So, my lord, here the case is one co-sharer says, please stick to the original sanction plan. Another co-sharer says, please let me violate the sanction plan. My lord, we are at amidst in a situation. They will come up before the court. They will create a situation where orders are passed that we have to act upon. And when we have to act upon, we have to act upon the last approved building sanction plan.
Can this,
My lord, may I submit?
just a- can this be regularized?
Lord?
Can this be regularized?
This is the old plan of municipality time.
My lord,
The shifting, can it be regularized?
my lord, half a minute, my lord.
Provision for regularization per se. The word regularization is not with us. But my lord, there are orders of Supreme Court, but that is passed under the complete justice powers of the Supreme Court, my lord. On our corporation also, but then, my lord, this feud has to be, this is basically, my lord, to be honest, my lord, to be my submission beyond the instruction is, the water reservoir, whether in front or whether in back, does not create a dangerous situation for the building to fall down. So prima facie, my lord, the corporation may not enter into the premises and look into the nitty-gritties there. But if they come up before the court of law, then we have to act in accordance with the last approved sanction plan. Where do we go?
My lord, may I pray
No, but
your
if
lordship
this,
to come at page 25?
Just a minute.
Just, my lord, page
This is-
25.
If this is demolished,
My lord,
then the entire building will not get water,
the entire building will?
not get water.
My lord, they have to understand that, yes, perhaps so, yes. If they do not have any other.
Because this is where the water goes and then it gets pumped to different
Yes,
floors.
subject to correction, my lord, yes.
Yes,
My lord, please once come at page 25.
one,
Page 25, P3.
yes.
This is a clearance certificate in respect of permanent water and sewerage connection. Reference, building on such and such plot. The building on plot number such in block AH in sector 2 of Salt Lake City has been inspected as per owner's application dated 6/8/86 and found to have been constructed in respect of first floor as per approved plan. Permanent water connection and sewerage connections are recommended. Date of completion of building as stated by owner is 1st November 1985. So in the year 1985, the building was constructed, underground reservoir was constructed, and on basis of which document of they say
A sanction plan, sir. Where's the sanction plan? The sanction plan must be showing the reservoir.
Original.
Show the sanction plan. Where's the reservoir in the sanction plan?
Better he get it Xerox, my lord. This is so old.
most probably this should be the ground floor ही तो ये था underground ये था पूर्व
Not subject to correction, my lord, there is no reservoir mentioned in the ground floor.
Then how have you come to the conclusion that it was in the front, it was in the back?
But there is no reservoir mentioned at all.
So you see the feasibility and decide this.
No, this has to be checked, my lord. Perhaps this is the prima facie view, my lord. I have not got the opportunity of looking at it. It large. My lord, let him give a Xerox copy of this. I will take it up with my officers, my lord. But my lord, if his case is that if it is case is that in 1985 the reservoir was in the front and the private respondent says, no, it was at the back, then brought into fund. This is something, this has to be in trial, my lord. What can we do here?
My lord,
And my lord, I am not disputing
the
page
complaint-
25 at all. Because it says approved sanction plan.
the dispute primarily is between the brother and sister.
So
For
go to the
the-
civil court. Why are you dragging everybody there?
Because that property by law cannot be partitioned. She has specified rooms, flats. She declares herself that I'm in the position of the ground floor flat. Now she either wants more because her mother has donated her 1/3 share to the brother, and this is the real cause of the dispute. In the trial court, she has lost. She has gone to the appellate court. And
Yes, where's your counsel? Still
in court number 11 at the moment.
We'll have it tomorrow, Mr. Nag. Then.
Only blood will pass a bit of water.
The petitioner has filed the presented petition, being aggrieved by the impugned order dated 13/4/2024, passed by the Commissioner, Bidhannagar Municipal Corporation, whereby the petitioners are directed to demolish the unauthorized reservoir, underground water reservoir situated at the back portion of the property and to construct and to reconstruct the same as per the building plan, as per the sanctioned building plan. Bracket में in the front, at the front portion, full stop. Sanctioned building plan. All right. The case of the petitioner is that the deceased father, right?
Yes.
Deceased father of petitioner number 1, the original lessee of the plot, by virtue of a lease deed dated 12/9/1979, had constructed a 2-storied building pursuant to a valid sanction plan dated, what is the date of 1980?
1985.
1985.
Completion date.
Valid sanction plan
Sanction plan
approved by the corporation in what is the date? 85, 86?
85.
86, sir.
Page
25.
86.
60, valid sanction plan, page 25, 1986, full stop. Valid sanction plan for first, second, third floor. First, second, जहाँ लिखा है ना, वहाँ third floor. First, second, third floor, full stop.
Sanction plan is of 1912.
16/8/86 application.
Confusion আছে বলুন।
Valid up to 19.
Valid up. Sanction plan date of 13/2/1980.
Sanction plan dated 30th of February 1980.
Your application is 86, sir, page 25. See the application.
That is completion certificate. Date of sanction plan is 13th February 1980. Date of completion is 85.
This is the completion which is on page 25.
As per application,
1980.
the permission to
Permission.
the sewerage and the water connection.
1980, yeah. Sanction plan in 1980 से लेकर चला. Then what had happened? What is the after this dispute?
There was no dispute.
With
The
your,
dispute has cropped up recently. When
did the dispute crop up, sir?
In
Are there any suits pending?
Yes, dispute is pending in the appellate court. First appeal of both the parties are pending in Barasat before the district judge
Regarding what?
Barasat. Regarding, they had an arrangement between them. She is married. She was married. The sister was married approximately 35 years back in a very affluent family. She has a very good standard of life. Now the dispute cropped up. She wanted to sell this ground floor portion.
Okay.
To third person. The brother said, no, I cannot sell this portion. Then the arrangement was reached that, okay, get it, rent it out. We will share the rent and a portion of the rent will be adjusted in the common expenses for to pay the rates, taxes, these, that.
On following his father's demise, following his father's demise, the respond number 4, the disputes arose, multiple litigation were filed between the legal heirs, full stop.
Civil as well as criminal.
Based on a complaint lodged by respond number 4, the corporation issued a notice alleging unauthorized shifting of the underground water reservoir from the front to the back of the property, full stop. A hearing was held thereafter, a self-demolition order dated 23/2/2024 granting the petitioner 3 months time to carry out the directions was passed, full stop. Upon non-compliance, a final demolition notice dated 3/10/2024 was issued, scheduling the demolition on 28/11/2024, full stop. Learned counsel for the petitioner states that the construction submits that the entire construction, including the underground reservoir, was undertaken more than 45 years ago, full stop. He submits that the completion certificate was issued after conducting the inspection on 18/6. This is the one, right? Completion certificate, page 25.
No, my lord, this is not a completion certificate.
This is what?
This is a permission, a pursuance to the completion of the house,
Right.
that the water and the sewage connection.
Clearance certificate in respect of permanent water and sewerage connection.
क्या लिखवाया है? Right. उसके बाद 45 years ago. The petitioner further states that they had got the approval of permanent water and sewerage connection in the year 1986. Full stop. He states that no objection has ever been raised by respondent number 4, right?
Yes,
by private respondent number 4 till the complaint was filed. Till the complaint was filed. Full stop.
Respondent number 2, my lord.
Respondent-
Municipality is
No,
respondent
respondent number 4 filed the complaint.
Yes, my lord.
That's what I'm saying. Till respondent number 4 filed the complaint. Full stop. Learned counsel for she is not here. Learned counsel for the respondent, municipality. Municipal corporation. You'll take instruction. Let me know.
We have instructions. My lord,
All right.
only one
This-
thing, my lord, if they supply the
Le-
plan
learned-
on oath,
Yes.
we can review the plan once again.
Lord, copy of the plan is annexed.
Learned counsel for the petitioner states that as per the sanction plan, there is no water reservoir which has been duly marked in the sanction plan, and that the allegation that there is deviation in the sanction plan as far as the shifting of the underground water reservoir is concerned is factually incorrect. Full stop. Learned counsel for the respondent states that he shall come back with instruction after after going through the sanction plan to make further submissions to the statement made by the learned counsel for the petitioner. Full stop. He seeks and is granted time. Let this matter be listed on. When do you want?
Weekends.
Next week. Next week. We'll have it next week. Let's try to find a solution. Otherwise, shut the reservoir. Both will go without water.
It appears, my lord, one does not stay, one stays.
That's the problem. That's why they are creating all the difficulty. We'll see, just see the sanction plan.
Yes.
Because if there is no indication in the sanction plan,
Then there has to be a reserve.
there has to be a reservoir, then we'll regularize this one. Then we'll, after an
In case order of the Supreme Court, my lord, there the Supreme Court had given a bit of leverage to this minister.
Much more.
My lordship, I'm praying for the petitioner lordship.
I'm for
This
the
is my
municipality.
affidavit of service. Lordship,
My lord, I am
the
appearing on behalf of the state.
private respondent number 8 is constructing an illegal construction of a G+4 building without leaving any site space. And petitioner's shop is the exact adjacent shop to the illegal construction, lordship. Lordship, I have annexed the photographs in page number P2. The annexed is P2. Page. Lordship,
corporation.
and I have.
Who appears? You appear?
Okay, lordship, and
You are appearing?
if your lordship would kindly seize.
This has been issued.
Lordship,
We have to,
one.
we have to inspect the premises once. Thereafter, my lord, notice will be served, my lord, upon the parties for hearing.
If I may be allowed to submit one thing, lordship, if your lordship would come to page number 11 of my petition, lordship, your lordship would find that the dark number 3588 is a doba land, that is a swampy land over which the construction is being made. As per municipality rules and
I see
regulations,
tag number 4375.
3588 in page number 11. It's the dark number, the plot where the construction is being made.
At the top, 3588.
No,
No, my
lordship.
lord, third.
Third, lordship.
Third.
3588, the below third, it's written in Bengali. There is, my lord, and also lordship, there is no,
That much Bangla, I don't know.
okay, and lordship, there is no building sanctioned plan, there is no site space, stop work notice has been given, and when we have gone to oppose the said construction, they have threatened us, we have lodged a GD. Regarding the illegal construction, we have made representation to the municipal authority, no steps are being taken, lordship. In spite of a stop work notice, they are building a G+4 building over a Doba land, lordship. There is a risk to public safety.
Stop work notice, my lord, this writ petition was filed. My lord, we are waiting for an order, my lord, so that inspection, physical inspection be made, and thereafter, my lord, we will serve notice for hearing. If your lordship kindly direct the municipality to proceed with the representation made by the petitioner, we will act accordingly.
By this time, a demolition notice needs to be was supposed to be passed, lordship.
Fix a time frame.
Yes, your lordship.
The petition, the present writ petition is. The petition has preferred the present writ petition being aggrieved by the inaction of the respondent authority in not taking any action against the alleged illegal and unauthorized construction being carried out at what is the
Address.
address?
Yes.
Being carried out at
Tag number 3588,
this is
15 A BT Road, Post Office Panihati, PS Khordha, District North Chobbish Pargona.
para 7, page 5.
Para 7, page 5. Yes, Your Lordship. This. Yes, 19 BT Road, near Panihati Telephone Exchange, ward number 10.
Being carried out at 19 BT Road near Panihati Telephone Exchange, ward number 10, Panihati Municipality. PO Panihati, PS Khardha, District North 24, Parganas. Full stop. At the instance of the private respondent. Who appears for private respondent? You?
And for the state.
At the instance of private respondents. Full stop. It is the case of the petitioner that the private respondents are carrying out illegal and unauthorized construction in the form of a 5-story building at the above mentioned plot. Full stop. At the above mentioned site. Full stop. He further states that the alleged site is a DOBA land, and the private respondents are carrying out the unauthorized construction without any sanction plan. Full stop.
Without leaving any site space. Without leaving any site space.
Comma, without sanction plan and lacking mandatory side spaces, comma, which violates the West Bengal Municipal Act 1993 and the West Bengal Municipal Building Rules 2007. Full stop. He further states that despite the work stop notice issued by the Panihati Municipality, comma,
This is a stop work notice dated 7/9/2024.
Work stop notice dated
7/9/2024.
7/9/2024. The private respondent has carried out the respondents have carried out the unauthorized construction, comma, posing risk to the structural stability of the building and potential harm to the petitioner's shop
and the public
as well as nearby residents and passerbys. Full stop. Petitioner has repeatedly lodged complaints with the municipal authority, but the same has not been acted upon. Full stop. Learned counsel for the respondent Panihati Municipality states that the municipality has acted upon the complaint of the petitioner and has issued a work stop notice dated so and so to the private respondents who are alleged to be carrying on the unauthorized construction. Full stop. Learned counsel for the respondent municipality further states that they are ready and willing to decide petitioner's representation dated 31/10/2024. What is the date? 31?
Yes,
4th October 2024. Full stop. Learned counsel for the petitioner states that he shall be satisfied if his representation is decided within a time-bound manner. Full stop. In view of the statements made by the counsel for the parties, this court directs the respondent Panihati Municipality. Any particular respondent in Panihati or the respondent Panihati Municipality to decide petitioner's representation dated 4/10/2024 within a period of
Board of Council.
how much time? How much time?
For this one.
But 4 weeks, my lord, before that inspection is required.
Within a period of 8 weeks,
4 weeks.
within a period of 8 weeks, 4 weeks, they can't do it. Within a period of 8 weeks from the date of communication of this order, in accordance with law, after affording an opportunity, after affording an opportunity of personal hearing to the petitioner as well as the private respondents. How many, one respondent or
Two respondent, Lordship. Private number 8 and 9.
private respondents? 8 and 9.
And if Lordship, the illegal construction is found,
By way
a
of
demolition, a section
order.
280 notice may be given.
They'll decide it, they'll do whatever action they have to do. With the above direction, the present petition is disposed of.
Yes.
Affidavit of service is taken on record.
And this is also mentioning mentioning service. Affidavit service and a mentioning service.
What is this?
Mentioning service.
But I appear on behalf of the petitioner.
I appear on behalf of the respondent municipality.
Now, my lord,
Respondents number 2 and 3.
my lord, your lordship may kindly consider, kindly come to only one page. Page, my lord, 44. My lord, it starts from 39. But in order to cut short the matter, I just draw to my lord's kind attention
To
that
page,
there
page, sir?
page, my lord, it starts from page 44. The order starts from page 39, but the relevant portion is at page 44. Now, in a suit for declaration of title and injunction, my lord, the order was that a suit be and the same is decreed on contest against the defendant number 1 with a cost of rupees 100 and ex parte against the rest with a cost of rupees 200. It is hereby declared that a plaintiff has acquired right, title, interest and possession of the suit property on the basis of registered sale deed dated 5/3/74. It is also declared that RS Khotian number 57 has been wrongly recorded and it is not binding on the plaintiff, and the names of Abdul Soban and Musra Misri has been recorded in the Khotian. So it is also declared that the order of vesting passed by the state government in respect of the suit property is illegal and not binding. The defendants are hereby restrained permanently from interfering with the peaceful possession of the plaintiff in the suit property in any way.
Yes.
Now, this being the position, my lord, I had ascertained that no title appeal was filed by the government. Now, therefore, my lord, the rights, so far as the petitioners are concerned, stood crystallized, insofar as the particular property is concerned. Now it appears, my lord, that my lord, I must submit to my lord's, my lord, that thereafter application has been made for recording the names of the present, my lord, owners. But the schedule of the lands which has been specified in the plan and which was the subject matter of the suit, that cannot be altered. Now it appears, my lord, that Dalkhola municipality, my lord, without initiating any valid acquisition proceeding, had, my lord, taken steps, my lord, to make a children's park. My lord, I say, my lord, your lordship may kindly come to page 98. Page 98, 99, I have given 2 photographs in order to give the impression to the court what the Dalkhola municipality is doing. Now, my lord is well aware, and my lord, your lordships have laid down the law that I cannot say that land I must have. A land, I may be the owner of a land, but my lord, this land can be taken by the government or by any authority, but that has to be taken in accordance with the valid acquisition proceeding or the law prevailing in the field. Now, your lordship is well aware of, my lord, that, my lord, now the law which has come is right to fair compensation and transparency in land acquisition, rehabilitation and resettlement. Now we had made a particular, first of all, we made a representation that why you are taking the land of the petitioners. And my lord, I have the further, my lord, I told my clients, my lord, to give further, my lord, photographs to, so that, because this repetition was filed, my lord, sometimes back, and my lord, the business of the court did not permit the matter, my lord, to be taken up. Now, my lord, yes, but it seems, my lord, that the rods and other things for the purpose of making construction, that is going on. Now, fencing of the wire had been taken for establishing and opening children's park by Dalkola municipality. What I will be contending before my lords is that this action is wholly illegal and without any authority of law, and land cannot be taken without the recourse to law and without initiating a valid acquisition proceeding. Now, I in the prayer of the, in the particular, my lord, prayer of the writ petition, my lords will be pleased to find that, my lord, what prayers I made in the writ petition. I had made a prayer that, first of all, my lord, the cancellation of this action which has been taken, and if you want to take the land, certainly you can take. My lord, what I should be submitting to my lords, my lord, that if the Dalkola municipality wants to take the land, they may certainly take it, but that should be done after giving me the appropriate amount of compensation, and, my lord, after complying with the provisions, my lord, in accordance with law. But they cannot act fast and loose in a manner, my lord, which they like. And I have, my lord, indicated in my prayers, my lord, that kindly comply with the particular provisions, my lord, under the Act of 2013. And then you take the land and do whatever you want to do. I am not standing in the way, but, my lord, my right, as it stood crystallized, that cannot be taken away. This is my submission.
Why a writ petition for this?
Millard?
Why you have filed a writ petition for this? For claiming there must be some other forum for seeking compensation.
Compensation. Millard, I say, Millard, this action has been taken by municipality. Now, Millard, alleging the action of the municipality, I have come up before my lords. That is only the reason. Because that was also initially coming to my... Yes.
We'll hear you, Mr. Chaturvedi, after lunch. You are appearing for?
I appear for the respondents number 2 and 3.
Millard, Dalkola municipality.
I am the municipality.
You are the municipality.
I have been granted the land by the state.
By the state.
By the 5 and 6. I have the document to show. After the decree that my learned friend is not relying upon, that he asked the state government to mutate the land in his favor. But the state government, does not do it. He files an application before the Land Reforms Tribunal. The tribunal directs the BNL LRO to look into the matter and pass a decision. The BNL LRO has passed an order which is suppressed in this writ petition. In paragraph 8, kindly comes to paragraph 8.
Petition states that no reasoned order.
That no reasoned order has been passed for correction of record of rights pursuant to the order passed in OA number so and so. This, my lord, order has been passed on 11th of July 2024. And the writ petition has been affirmed, Lord, sometimes on the 20th of November 2024. This rejects the claim of the petitioners in view of the fact that the land is still recorded in Khatia number 1, which indicates that the land belongs to the state.
We'll have it after lunch. You are aware of this?
Yes, yes.
Please. Yes. Lord, I was. Yes, sir.
না আমাকে না তুমি বলে নেবে না বলে না তুমি
Lord, I was referring to paragraph 8 of the writ petition. Yes. That order which you were showing. Yes. And in furtherance to that, that an order has been passed, he says the petitioner states that no reasoned order has been communicated. He's saying this in November 2024. And then my lord kindly sees, my lord, the order that I have handed up to my lord. That is on 11th July 2024. Yes. I have handed up a copy of this to my learned friend appearing on behalf of the state and the petitioner. Yes. Now, my lord, right, wrong, indifferent, my lord, relying on the Supreme Court decision passed in Bengal Ambuja, my lord, the state has taken a stand. Yes. A state would justify it, my lord. But I say that this, my lord, has to be assailed. This has to be assailed to have an unclinching proof with regard to the petitioners being entitled to the lands and being in possession of the lands. But that entitles them to any compensation under any act. That whether 2013 act would apply or not, I come to that later. Yes. Now kindly see, my lord, paragraph 10. The petitioner states that an application for execution of the judgment and order, my lord has very kindly got it, dated so and so, being title execution case number has been filed by the petitioners and title execution case is pending for final decision. Lord, if I understand it, Lord, in the right context, it would mean that the petitioner has been able to obtain a decree and has put the decree into execution to get possession of the land. Now, can I have the possession of the land as well as a compensation simultaneously? He is maintaining the petition. He is maintaining the petition. He discloses on admission that he wants to get his lands back. For that, a list is pending. And then he invokes the prerogative jurisdiction of my lord's court to say that grant me compensation. So I say these are mutually destructive, my lord, pleadings. And for this reason, my lord, the prerogative jurisdiction of this honorable court cannot be invoked. Now, how we came into possession of the lands? My lord, the state has, my lord, made over the lands to us for constructing. You are saying, Mr. Chaturvedi, that his title suit which deals with the fact whether he is in possession of the land or not.
Whether he has a title in respect of the land or not.
Land or not.
Possession, he admits that he is not in possession.
Right.
Hence, he has filed the title execution case
Right.
that I have obtained a decree, I want the possession of my land.
That is pending.
That is pending.
All right.
Now,
At the same time, he's asking for compensation.
compensation. Milord, before I show Milord the document, kindly sees what are his prayers. Kindly sees paragraph page 16.
Yes.
Kindly sees prayer A.
Prayer A.
Let rule do issue under the seal of this honorable court, asking the respondents and each one of them to show cause why it or mandamus should not go, commanding the respondent to rescind, cancel, withdraw, and forbear from giving further effect to the action of taking land of the petitioner without complying the statutory provisions and to act in accordance with law. And then, Milord, kindly comes to the next prayer. Kindly skip over the top 5 lines. Mandamus should not go, commanding the respondents to comply with provisions of section 19 and other subsequent provisions of right to fair compensation, transparency, so and so Act 2013 in respect of taking action for opening up and to make payment of compensation. And then prayer C, again with regard to compensation.
Yes.
These are mutually destructive, my lord, prayers. One. Second, my lord, that the jurisdiction of my lord's court, my lord, has been, my lord, invoked. One, on suppression of facts. Two, on in gross abuse of process of law. Now, how we came into possession of the lands? Lord, kindly sees the state, my lord, has settled the lands in their please. Lord, kindly sees, my lord, Lord, kindly sees, my lord, the second page first.
Yes.
Lord, this is 10th of June 2024. Where we ask, my lord, the subdivisional officer, I am to inform you that earlier we have sent the proposal for setting up a children's park for which 0.61 acres of government vested land was identified. In regard, weighted DPR has been prepared and submitted by the chief engineer, so and so, has already been floated. So an NIT has been floated. So I request you to kindly take necessary steps to make the proposed site for children park encroachment free.
Yes.
And then, my lord, kindly see the top note sheet, which is, my lord, a letter dated 6th of August 2024. This is, my lord, from the subdivisional officer to the SDPO, Block Land Reforms Officer, and copies marked to us. Apropos the subject mentioned above, the chairman so and so is going to lay fencing of the proposed children park under Dalkola Municipal so and so area 0.61 acres, which is lying in Khatian number 1.
Yes.
That is collector's Khatian. So the land, my lord, it still remains with the state and has been duly approved by the Urban Development and Municipal Affairs Department. The work of fencing shall take place on 7/8/2024 at 11:30 AM onwards. Fencing, there is apprehension of breach of peace in the locality. Hence, SDPO Dalkola Islampur is requested to deploy sufficient personnel to avert any untoward incident. In view of the above, BLRO Korandigi is requested to take necessary steps for measurement of the aforesaid scheduled lands on 7/8/24 so that construction of the said park can be started at the earliest. Thereafter, NIT has been floated and the fencing admittedly has been done and the construction is soon to be completed.
Yes.
So we have, we are the beneficiaries of this land. A land standing in the government's name in Khatia number 1 has been made over to us on which we have constructed the land. This is, insofar as the facts are concerned. And on questions of law, I have not submitted. At the risk of repetition, I say that the prayers are mutually destructive. Repetition cannot be maintained.
Yes, you're appealing for the state.
Land has been made over to the Milord municipal for Milord establishing a children park. So Milord, he cannot go side by side to asking for two prayers at one time. Milord, if your lordship kindly takes page 77, your lordship would find title execution case number 3/2024. Has your lordship got it, page 77? Yes. He is asking for the land should be made over to him by Milord filing this execution case. And at the same time, Milord, he is asking for compensation. Milord, land belongs to the state. It has been vested to the state. And Milord, that has been, Milord, handed over to the municipality, Milord. If your lordship kindly takes page 2 of the order of the Milord BLLRO, Milord, my landlord has just handed over, Milord. Yes. Milord, penultimate paragraph, internal page 2. Yes. On verification of records of right, it is learned that the suit plots of land number such and such, Moja Dalgulas found recording in arrest Koita number 57 and name of such and such against those plots. Further verification, it is also evident that the specific noting has mentioned such and such that are was corrected under section 5A, 45A of West Bengal State Acquisition Act, white case number 144 1971. 1971, it was vested, Milord. Yes. In this connection, observation of the Supreme Court of India in civil appeal number such and such, while last sentence, while passing the judgment in the said case, the Honorable Apex Court observed the learned subordinate judge did not have the jurisdiction to entertain any suit. Yes. With respect to the said property in the light of the provisions of 57B, A, B, and C of the West Bengal State Acquisition Act. Section 57 of the West Bengal State Acquisition Act says brought to jurisdiction of civil court in respect of certain matters. No, subsection 2, no civil court shall entertain any suit on application concerning any land or any state or any right in such estate if it relates to alteration of any entry into the record of rights finally published, revised, made, corrected or modified under any provision of chapter 5. Finally, when passing the order in such case, the Honorable Supreme Court once again categorically stated that the civil court, Milord, did not have the jurisdiction to deal with the involved property. So, Milord, in terms of these provisions of the Milord Estate Acquisition Act, civil court, there is a bar on the civil court to Milord adjudicate the issue. Land belongs to the state. It has been duly made over to the Milord municipality. This is my submission. Yes, sir.
Lord, at the outset, I should submit to my lords that I cannot make twofold prayers before my lords that I should be given the land and I should also be given the compensation. There is no doubt about it. I cannot do that. The law as it stands as on it. Now, I think, my lord, a submission was made subject to correction of my lords that I have suppressed certain things in the writ petition. Now let me see as to whether, my lord, there was suppression, because I should draw to my lord's kind attention with regard to the original order which was passed in so far as the matter is concerned. As I told your lordships, that after I obtained a judgment and decree from the learned court below, my lord, I had filed an execution case and that is pending. Therefore, my lord, in the midst, certainly Dalkhona municipality or the government has a right to take my land, but the recourse to law has to be done. Therein no statement has been made, subject to correction of my lords. Now kindly see page 138. And my lord, my lord, I will be appealing to my lords. I will be giving some inconvenience. I will be creating some inconvenience to my lords. To my lord, just suppose this document of 27/6/2024, which was handed over by Mr. Chaturvedi to my lords. You will kindly see 138 and Millard, the document Millard which has been placed by Mr. Chaturvedi. Millard, I file an application before the learned tribunal. Now kindly see page 138 of my application, that the applicant submitted a representation for correction of record of right in respect of the suit plot of land on 5/7/2004, which is still pending.
Where
The
are you
learned-
reading, sir? Page
Millard,
one.
page 138, Millard.
Yes. Which paragraph?
Learned government representative submits
Yes.
that the BLLRO concerned should keep in mind the statutory provision of law while disposing of the representation, as the land is vested to the state.
Yes.
The BLLRO Korondike Uttar Dinajpur is hereby directed to dispose of the representation in accordance with law within 6 months on the date of communication of this order, by giving a fair and reasonable opportunity of hearing to the applicant and other interested persons, if any, by passing a reasoned order. The applicant is directed to serve a copy of this application along with the annexures and also copy of the order passed this day upon the authority concerned within 4 weeks on the date of obtaining the certified copy. The concerned BLLRO is further directed to communicate the fate of the representation to the applicant within 2 weeks from the date of passing of the final order. If the applicant prays for a certified copy of the final order as per rule, then the concerned BLLRO should supply the same within 2 weeks. Now, in the recess, Millard, I had taken a specific instruction from my client where you communicated the fate of this particular proceeding, because the BLLRO was directed to pass an order. My answer was the answer which I got, that Millard, in the next page 139.
Yes.
Whereas it appears that Honorable LRTT West Bengal passed an order on 6/6/2016 in OA case number 1112 up to 2006 in the name of Abulabala Roy versus State of West Bengal and others, and the Honorable WBLRTT directed undersigned to dispose of the matter in accordance with law by passing a reasoned order after giving opportunity of being heard to all parties. You are requested to appear before the office of the undersigned on 19/8/2016 along with the papers and documents order of the tribunal, etc., in support of your claim over the scheduled land mentioned below. This letter was addressed by the BLLRO to the petitioner. Then, Millard, your lordship may kindly consider page 140. A miscase was initiated, as it was stated that I have suppressed it, Millard. I was looking into the document because from the top portion of this order, my lords may kindly consider after the order sheet, then miscase number 385 LRTT. This I was inquiring because I did not get this specific instruction. Then I was told that a miscase was, Millard, instituted by the BLLRO. Now, this is the miscase, and my client was called upon to submit all documents. He had, Millard, appeared in the proceeding. Now, Millard, your lordship may kindly another document I will be showing. That insofar as the title execution case is concerned, Millard, I come to learn that one date, Millard, one order they had given at page 83, that is this title execution case 3 of 2024. This has been fixed on 29/1/2025. Kindly see page 83.
Yes.
For filing written objection by the judgment debtors 4A, 5A, 5C, 6B, 7, 11, 12, 13, and hearing of the petition filed by the decree order. Now, thereafter, some must be, Millard, some other dates have been given.
What are you trying to say?
Yes. I want to say, Milord, that so far as this order is concerned, this order, Milord, which I find that, Milord, this order of 11/7/2024, here, Milord, the particular BLLRO had frustrated, or rather, he himself had disowned the validity of a judgment and decree passed by a learned civil court. He had frustrated and he had disowned the validity of an order or a judgment and decree passed by a learned civil court. Now, Milord, I find that there is a reference of a judgment, and in support of that, Milord, there was a reference of 57B. Milord, there was reference of 57B of the West Bengal Estate Acquisition Act. I find parameteria provisions have also been indicated in the West Bengal Land Reforms Act, which says that there is one thing which I should show to my lords, that notwithstanding anything contained in the Code of Civil Procedure 1908 or any other law for the time being in force, or any decree, judgment, decision, or award of any court, tribunal, or authority, no court shall have any jurisdiction to determine any question relating to land or connected with any particular matter which is required to be, Milord, inquired into by or decided. Therefore, I say, Milord, that if a judgment or decree has been passed, this BLRO, Milord, he does not have a jurisdiction, and he had referred to, I find, Milord, my lords have also taken note of that he had referred to a judgment of the Supreme Court. Kindly see page 1, SLP number 5902-5903 of 2015. Milord, I am handing over, Milord, I did not find that, but even then, at the risk of repetition, Milord, I am handing over to my lord.
What? I don't need it, sir. What are you trying to show?
I am trying to show that if the this particular block land and land reforms officer.
Go and show it before the execution court. Why before me? Today you are here before me. You are asking.
Milord, today I am before my lord, subject to correction of my lords, that I am, my only contention is.
Are you the owner today?
Milord?
Are you the owner of the land today?
I cannot.
Are you the owner of the land?
Milord, I am the owner of the land till today. But, Milord, there has been fencing. This fencing, I say, this you cannot do. I do not say that at one stage or I will be holding the land and I will be also paying compensation. This cannot be done.
But
this is not
what
the,
you are asking for.
This cannot be done.
You are asking for this, sir. Your
Milord, I
petition is
say,
asking
Milord,
for
with the
this, sir.
greatest of respect, kindly note my submission.
I will
Milord,
note your
as an officer of the court, I cannot say
Sir,
that.
you are asking, I am just reading out from your prayer clause. You are asking for this, sir.
Milord, I submit, Milord, that your lordships may kindly.
I am not saying it, sir. Your petition itself is saying so.
No, I am submitting, Milord, that.
This is your petition.
Yes, I had submitted in the first prayer not to give effect to the proceeding. Not to give effect to the proceeding, prayer A. And to comply with the provisions of section 19 of this Act of 2013. This what I understand, Milord, from my particular thing. I do not say that give me the land.
You're asking for compensation.
I am asking for compensation. I'm grateful to my lord. I am asking for compensation. Land they can take. Land they can take by recourse to law.
Today you don't. Anything you have to say, Mr. Chaturvedi? Anything more?
Paragraph 10.
Yes.
The title execution is on oath. On oath, he says that the execution is pending and he is pursuing it.
Yes.
Because the BLL's order has not been challenged anywhere till today.
And one thing more, kindly take note of that this order of 11/10/2024 has not been communicated to my clients. Kindly take note of it.
And that is, sir, that is for your client to.
No, that's right, Miller. I cannot make
Yes.
any more submission.
The petitioner the petitioners in the present writ petition are challenging the decision of the municipality in establishing the Dalkhola, right? What is it? Dalkhola Children Park on their land without following the mandatory procedure outlined in the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act, 2013, and without providing any compensation or opportunity for a hearing, thereby violating their legal rights. It is the case of the petitioner that Ablabala Roy, the petitioner's predecessor, by judgment dated 17/2/1998 in title suit number 183 of 1992, passed by the Munsif at Islampur, Uttar Dinajpur, secured a declaration of title and injunction over the land in question. By the said judgment, the vesting order passed by the state government, the property in question was declared as illegal and not binding on Srimati Ablabala Roy. It is his case that the said judgment was never challenged and attained finality. Full stop. Subsequently, an order dated 6/6/2016 from the 6/6/2016 passed by the West Bengal Land Reform and Tenancy Tribunal, OA number 1112 of 2006, was passed for the correction of land record in accordance with the judgment dated 17/2/1998 in title suit number 183 of 1992. Full stop. However, the said order has not been implemented. Full stop. The petitioner filed execution case number 3/2024, which is still pending for execution of the judgment dated 17/2/1998. Full stop. However, during the pendency of these proceedings, the respondent initiated proceedings for handing over the said land for establishment of the Dalkhola Children Park. Full stop. Petitioner states that he lodged a formal complaint on 11/9/2024 with the Board of Councillors of Dalkhola Municipality, as well as the District Magistrate and Additional District Magistrate of Uttar Dinajpur, highlighting the illegal use of land and demanding his fair compensation in terms of the so-and-so Act 2013, Fair Compensation Act 2013. Despite this, no action has been taken by the authorities. Thus, the petitioner has preferred the presented petition. Anything else, sir? Any other submission?
whatever submissions Millard I made, but only thing kindly record that Millard,
That's what I'm asking you.
I do not want land as well as compensation.
Alright.
I will be only pursuing for compensation.
Petitioner states that he only wants compensation, though his execution proceedings are still pending adjudication before the civil court. Full stop. Learned counsel for the respondent municipality, Mr. Senior Advocate Mr. Chaturvedi, submits that the petitioner has approached this court by suppressing material particulars and facts. He contends that the BLRO has already decided the issue. This is the issue of mutation of the land.
In terms of the degree.
The issue of mutation of the land in terms of the decree passed on 17/2/1998, wide order dated 11/7/2024, which though has been mentioned in the body of the writ petition, but the order though has been mentioned in the body of the writ petition as a matter which is pending, but a final order has already been passed, which is handed over by the respondent council. Full stop. It is contended that the land in question was handed over to the municipality by the state government, comma, and as such, comma, the municipality is merely acting upon the said transfer for public purpose, i.e. setting up of a children park. Full stop. It is further submitted that the petitioner has an alternative remedy available, and this court, comma, in exercise of writ jurisdiction, ought not to entertain a petition involving disputed question of facts. Full stop. Disputed question of fact pertaining to dispute of title. Full stop. Learned counsel, learned counsel for the respondent corporation further states that the prayer of the petitioner that the execution proceedings are still pending, and at the same time he is seeking compensation of the land are mutually destructible to each other, and both cannot be asked for at the same time. Full stop. Learned counsel for the state states that the land has already been vested with the state and is recorded as you had shown that where is that, sir? Shown as which page was that?
That is in the letter that I handed up to my wife.
Yes. Is recorded as is recorded in collector's Khatian and has been duly recorded in collector's Khatian, and the land belongs to the state. Full stop. The state has further allocated the land to the municipality. Full stop. This court has heard the submissions advanced by the learned counsel for the parties and has perused the pleading as well as the materials on record and the documents on record. Full stop. Upon careful examination of the record, comma, it emerges that there exists a serious and substantial dispute serious and substantial dispute with respect to the title and ownership of the land in question. While the respondent municipality claims to be in possession of the land pursuant to a handover by the state, the petitioners rely upon the judgment dated 17/2/1998 entitled suit number 183 of 1992 and the subsequent order dated 16/6/2016 passed by the Land and Reforms Tenancy Tribunal to assert their title and ownership. Full stop. The said issues cannot be effectively adjudicated in the exercise of writ jurisdiction under Article 226 of the Constitution. Full stop. Determination of such issues necessitates leading of oral and documentary evidence, which is beyond the scope of the writ court. Full stop. The jurisdiction of this court under Article 226 is primarily confined to cases involving violation of fundamental rights or statutory rights, where the facts are undisputed or capable of summary determination. Full stop. It is tried that writ jurisdiction is ill-suited for resolving intricate factual controversies or adjudicating disputed claims of civil title, which require detailed examination of detailed evidence, examination of witnesses, and a thorough appreciation of factual matrix. The task is best left to the civil court of competent. The said task shall be best left to the civil court of competent jurisdiction. Moreover, the relief sought by the petitioners essentially amount to restraining the state and municipal authorities from acting in respect of land which is in the nature of a civil dispute. Full stop. The petitioner has already approached the civil court and the execution proceedings are pending before the civil court in execution case number 3, right? In execution case number 3 of 2024. In execution case number 3 of 2024. Full stop. Since the dispute is still pending before the civil court, the petitioner is not able to make out any case for compensation under the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Settlement Act 2013, since both the reliefs are contrary to each other. Full stop. In light of the above discussion, this court finds that the issues raised in the present writ petition involve disputed question of fact and the issue of title that are and the issue and the same is disputed question of fact and the same and that are not amenable disputed question of fact and that are not amenable to adjudication in writ proceedings. Full stop. Accordingly, the present writ petition is dismissed as not maintainable. Anything else, Mr. Chaturvedi? Any other point which can be added?
My lord's order always covers the respondents, not the petitioners.
Both. I have been fair to both, sir.
No.
Yes, yes. Amenable. Yes.
For the third respondent.
My lord, I'm for the petitioner led by Mr.
Sometimes you're lucky, Mr. Bas.
Sometimes.
Huh?
Normal unlucky.
50-50.
No. 70-30. At least my lord's good.
Yes.
My lord, I'm led by Mr. Uday Shankar Chattopadhyay, my lord. I'm praying for not today.
There was a direction.
Not.
Direction for filing the report.
Previously, there was a direction
My lord,
of Justice Chandra.
it's River 32, you can file it. The direction. ভাই ছেলে বাড়ি কাজের লোক সবাই তো এলেন
There's no direction for report.
no direction.
Yes, there was a direction.
There's only one order, right? 24-12.
Yes.
Construction
Yes,
question of
yes.
residential if they had applied for sanction plan, one call, prayer was under. Section 2.
These are
Stay
two
the
connected
operation.
matters. One is appearing as item number 34 and this one.
Oh,
There are two connected matters.
34 may be taken up along with this.
Item number 34 and this one.
You are appearing in both?
No, my
Both
lord,
the
I'm
counsels are
appearing in only item number 20.
Property is the same?
No, just opposite.
Mr. Basu, you are appearing for whom? The respondent, private respondent?
No,
Not private.
for the municipality.
The official. Which item is there? Which is the connected one?
Item number 34.
34, देखो writ petition. What is the writ petition number?
556.
34.
29556 of
29556 of 2020.
Just take down. Let this matter be listed along with WP number so and so.
Take the কাগজ লিখে
Since both are connected, since the counsel for the respondent municipality states that both the writ petition are connected. Full stop. List on, when do you want?
Any day suits my lord. I am here.
My lord, any day.
This has been listed or mentioning or what?
Uh,
I think so.
my lord, this matter is
So you come, you make so much noise for mentioning, and then after that, dates. And this has been the status in most of the cases.
My lord,
And that is why I'm reluctant.
last 40 years, I am visiting these office on our court. When can you do it? Jump. When the matter is taken up for hearing, you can send it up.
You should just come to my court at 10:30.
Not necessary to come to me. I don't mention.
It looks like heavens are going to fall,
This thing is universal practice in our. For mentioning.
but then
this
people
jump,
don't come after that.
Thereafter, my lord, hearing matter, we seldom appear. This happens. This is normal, Shiva.
When do you want, madam?
my lord next week, my lord.
No, yes, okay, আসবেই না।
Ah,
কালকে করে নেব।
it's okay, my lord. Kindly fix it tomorrow.
Otherwise, my lord is not.
Tomorrow?
Grateful,
today.
my lord.
We'll have it tomorrow.
Yes, ma'am.
I'll take your,
Report.
No issues, my lord.
Grateful.
tomorrow? Tomorrow with this. Listed together. Order to kari diya.
I am for the petition. I am for the petitioner, your lordships. The petitioner is the cousin of late Jyotirmoyi Das, who is the owner of the property. But now, my lord,
What are you asking?
I am asking, my lord, to municipality just to, my lord, to construct a boundary wall. Just I want to construct my boundary wall. Just I made a representation before the municipality authority, but till today they did not take any step, my lord. That is why I have come.
Lordship,
Just to consider my representation, there is a page 27 only. Page 27, my lord.
Are you the owner of the land?
Yes, my lord.
Yes.
There is no the role of the municipality for the construction of the boundary wall.
Just
There
to
is a
take
dispute
permission.
between the adjacent the owner, lordship.
Municipality.
There
What
is
happened,
civil
lord?
dispute, lordship.
What happened actually? The private respondents, they are making objection, but
So
the
what can the
private they don't
municipality
have
do,
any
sir?
right to make such objection.
Sir, what can the municipality do? Go to the civil court, get an order.
Lordship.
But actually, I am the lord. Can this is Rayati property? This is
Sir,
my,
I understand you are the owner of the property, but what can the municipality do? You are seeking a prayer against the municipality to allow you to construct a boundary wall. What can they do? Are they stopping you?
no, my lord. Actually, my lord, the
This is
private
a private dispute between you and your neighbor, and he's not letting you construct the boundary wall. So you have filed a writ petition.
what I have said, my lord, a private respondent, my lord, I have made a application before the High Court, my lord, regarding police inaction. But
Very good.
that police inaction, in
yes.
case, my lord, what happened actually? The police says police to keep a sharp vigil at the local and ensure that no breach of peace takes place.
Very good.
This is the order.
Very good.
Now, my lord, situation is this.
Yes.
That I am the owner of the property, that is, I have every liberty
File a
to
civil
construct a
suit, sir.
boundary wall because they are making garbage over my property. They are gossiping with the teenagers at the midnight. They are drinking wine in my premises. So shall I not be take a construction boundary wall, my lord, for my protection?
So who's stopping you, sir? You are asking. You are
That is,
here
they are
in the-
making that they are making obstruction, your lord.
Go to the civil court, get a restraint order against them. You have filed a writ petition seeking a prayer against the corporation for construction of boundary wall. Are they stopping you? This is your dispute with your neighbor.
But situation is this, my lord. I am the owner of the property. So what
Who's
is
denying that, sir, that you are not the owner of the
Rayati? Rayati property is my property.
Oh God.
This,
Sir, I'm just
if I
asking you,
file
what is your relief
because
against
if I file a civil suit, what will because they are not the owner of the property, they are the stranger. They are the stranger, my lord.
Sir, I'm not.
They don't have any right.
You are not understanding what is falling from this court. All right. I'll dismiss the petition. You are not seeking anything against the.
My lord, but actually they are the stranger. Private respondents.
Private respondent, then they are not amenable to the writ jurisdiction. That's what I'm telling you. You're not understanding?
No, I have come before the municipality authority.
Sir, municipality, you don't have any relief against the municipality. Are they stopping you? You have made municipality a party only to get your writ maintained, the maintainability. But you don't have any relief against them. Your relief is against the private respondent.
Dispute between the two private respondents. I invite the municipality chairman. The chairman didn't take any steps. That is why I have come. That's the inaction and non-action on the part of the municipality.
Take down.
The dispute between the two private respondents, no doubt about it.
The petitioner has filed the present writ petition seeking construction of boundary wall on his property. Full stop. It is the case of the petitioner that the respondents are not allowing him to construct the boundary. The private respondents are not allowing him to construct the boundary wall. Full stop. In the present writ petition, the petitioner is claiming relief against private individuals and there is no relief which is sought against the Rajpur Sonarpur municipality. Full stop. the contention of the petitioner that he is unable to construct the boundary wall is only due to the objections raised by the private respondents. Learned counsel for the respondent, Rajpur Sonarpur municipality, states that the petitioner does not need any consent for the construction of the boundary wall, and that the dispute between the petitioner and the private respondent are private dispute and are civil in nature. And full stop. The respondent further states that the respondents, so Rajpur Sonarpur municipality, is no way obstructing or is stopping the petitioner from the construction of the boundary wall. Learned counsel for the petitioner admits this fact that the boundary wall is that the petitioner is not able to construct the boundary wall due to the objections by the private respondents number 5 and 6 in the presented petition, in view of the fact that the present dispute is private in nature and there is no element of public law involved in the presented petition. The same is dismissed. No cost.
I am for the petitioner. Here is the affidavit of service and the short written notes.
For the respondent number 9, that's the private respondent.
Lordship, I led by
Lordship,
Mr. Vimal Kumar Shah. He is busy in 30. Make short
let me
pass over,
confirm.
Lordship.
Kindly peruse the short written notes. The private respondent number 9 constructed illegal G+2 building with third floor.
Tomorrow.
Grateful, Lordship.
You will know.
Tomorrow. Not today, tomorrow.
Grateful, Lordship.
Affidavit service we kept at the court.
Tomorrow, sir.
Tomorrow I have one personal difficulty. Meet on Wednesday, please.
Day after tomorrow. Madam, day after tomorrow.
Wednesday. Deeply grateful.
Well, this is my read petition. This is the affidavit of service. I serve all the.
Municipal.
The matter relating to my lord, the given the pensionary benefit, the petitioner is was the retired employee of Jiaganj Azipur municipality. After more than 33 years service, my lord, the pensionary benefit, only provisional pension has been given by the municipality.
Lordship, this is the instruction from Director of Local Bodies.
What is the instruction?
Our
Not having requisite number of yes.
Lordship, as per record, first paragraph, Lordship, made in the service book of the petitioner and BOC resolution dated 2009, the petitioner was appointed as LD clerk in the scale of pay rupees 3,350 to 6,325 on 2009 by the municipality authority without the approval of the government, Lordship.
This is the case you should cyclostyle this and put it in every case.
Has come from the Director of Local Bodies.
page 21 is the approval.
2009, he was appointed.
Who are you?
2009, municipal.
Municipal. He was appointed in 2009. It was regularized.
Yes, my lord. Page 21 is the approval given by the Director of Local Bodies. Director of Local Bodies giving the permission. Page 21, kindly see, my lord. And on the basis of this, my lord, the later, my lord, the municipality given the appointment, absorbed the petitioner as a permanent employee. Although I work more.
For that, my lord, casual work.
Before that, I was casual worker, but kindly see, my lord, page 21.
Oh, these are all okay. Yes.
And the document already forwarded before the director.
And similar.
File your affidavit so that we can pass an order.
My lord, document already forwarded before the.
That's right, sir. File an affidavit so that we can file a formal pass an order.
I too, Lordship.
Yes, you have to, madam.
Disclosing their stand. Otherwise, my lord.
Tomorrow you will.
Tomorrow.
I'm saying tomorrow you'll change your stand. You have to file an affidavit, not tomorrow. The petitioner in the present writ petition is aggrieved by the inaction of the respondent, comma, in not releasing his pensionary benefit,
Right.
which have not been dispersed since his retirement on October 31st, 2020. Full stop. It is the case of the petitioner that he joined Jiaganj, Azimganj municipality as trade tax collector.
No, I was observed as a lower division clerk. Initially, my lord, as a trade tax.
As trade tax collector on 7th August 1987 as a casual employee.
And 2009, observed as a lower division clerk. 2nd March 2009. Page 22, my lord. Page 22, the appointment letter issued by the municipality. Page 22, Annex P4. On the basis of the approval given by the director of local bodies.
All right. Trade tax collector in 87, comma. Before that, you were appointed as trade tax collector, comma, was appointed as a clerk food licensee 1988, 87 वो हो गया trade tax, 88 licensee हो गया, and was permanently absorbed as a LDC lower division clerk in 2022-2009. Full stop. After his retirement in the year 2020, October 2020, he applied for his terminal benefits
2024
on 29th
October 2024.
No, 31st October 20.
31st October 20.
It was Sudhir
30th October 2020.
Yes, 30th October 2020.
Yes.
31st October 2020. 31st October. Retirement on 31st October 2020. Yeah, page 25. Full stop. After so and so, he applied for his terminal benefits on 29th October 2024.
And petitioner also given my lord the provisional pension.
Yes, but the respondent municipality failed to release his entire terminal benefits except provisional pension of rupees 9,255. Full stop. It is a submission of the petitioner that the non-grant of pensionary benefit is causing undue financial hardship to the petitioner. Full stop. Learned counsel for the respondent state as well as the municipality seeks 2 weeks time to file their report by way of an affidavit, exception to the same if any within 1 week, list after 4 weeks.
মামলাটা একেবারে
জান আমরা স্ট্যান্ড পার চেঞ্জ করে দিয়েছি জানেন না আপনারা জানেন না আপনি তো ভালো করে জানেন
State doesn't apply their mind.
They are saying that the government had didn't.
Every matter, it is the same story.
And in this case, they have given the approval before observation.
Every matter they have given
Now,
approval.
some cases, my lord, without approval.
Very few cases.
Very
Majority of the cases, there is an approval. And people have worked for 30 years, 35 years, and no pension. Next. Next is also same.
Same, my lord, the same municipality.
Same municipality, same order, date of retirement.
No, my lord.
31st July 2024.
And I'm for the state, my lord.
List of this.
What is the date of retirement, sir?
Retirement, my lord.
31st July, my lord, 2024.
31st July 2024. 2020.
Absorption same hai. What was he working? Initially appointed as storekeeper. Okay. In 87.
Thereafter, my lord, page 18. Lower division clerk, page 18.
And then regularized. Casual employee, same, 20th February 2009 as LDC. Same LDC, right? Lower division clerk. Retired on
31st July 2024.
31st July.
And the same amount is receiving.
When did he make a representation?
First August 2024.
Representation 1st August. Same one.
And I'm for the state.
You are for the state?
My lord.
Madam, file your reply. All right.
Unless pension papers are sent by the municipality.
Already.
All sent, all sent.
In one cases, my lord, your lordship passed an order. What happens, my lord? After communication of this order, my lord, they changed their stand, my lord, and rejected the prayer of the petitioner, stating that he has not absorbed in terms of the one. That's why, my lord, I am placing before your lordship to
We'll see.
adjudicate from this court.
Let the
Yes,
replies come.
without affidavit, my lord, they will not.
Without affidavit, I can't pass it.
My lord. Earlier occasion, your lordship, on the basis of their submission, your lordship passed that order. That order is with me, my lord. Since your lordship giving the direction to the local bodies
Yes.
to consider
Yes.
taking the advantage of this, saying that local director of local body rejected the claim of the petitioner. That's why, my lord, I am placing before your lordship to file the affidavit of service and disclose their stand so that the court can pass the mandatory order upon the responding authorities.
We'll see that.
Grateful.
I am for the full Ganesha Corporation.
I am the private.
But I am for the petitioner. Don't go into the volume of the paper. It is very short. 263, your lordship kindly once.
I have made it so bulky.
The agreement and all that, that's why it's voluminous. Page 263, if your lordship takes up, I have twofold prayer before the municipality. The fraud has been practiced. So, the invocation of power under section 397, and apart from
Cancellation of plan.
And if your lordship, because there are 265 I have given, there are affidavits affirmed, there are proceeding pending before the civil court in intercept between the parties. So there has to be a procedure that they will have to give, that there is no legal proceeding pending in respect of that. Affidavit has been affirmed, but though the proceedings are pending, but that has not been disclosed. But if your lordship takes up once 266, because apart from the element of cancellation, I have indicated from Roman 1 to Roman 5 at page 266.
You are the owner of the plot.
Adjoining plot. My plot is 47/4.
Why-
Roman
is the-
1 to Roman 5 is the deviation from the sanction. I am challenging the sanction side by side. Page 266, internal page 4 of my
So you are the
complaint.
neighbor.
I am the neighbor.
What
I
is
am
the
the
pro-
neighbor. I am touching to the property also of where I have certain right, because Dolly is the owner through whom a purchase agreement was entered into. For that, the suits are pending. I am not adjudicating anything. Inviting your lordship for civil court, which is of the season of the matter. But regarding the page 266, apart from cancellation, these are the deviation I have specifically pointed out. That though there is a sanction, I challenge.
How do you know the deviations?
I am the neighbor. That's why kindly see what I have mentioned.
Neighbor, you're not a structural engineer.
I am not a structure engineer, but as far as I have to plead what is there. Otherwise, it is not. Since I am making a complaint, I have disclosed. What I want before your lordship, let this be considered by the KMC and passed order.
Mr. Ghosh,
Well, I may consider, because it is a representation. The law says that in the case of the 397 applies regarding, but the position is this, my lord, he is making this representation and 31st of October 2024. But a March prior to that, when the building plan was sanctioned and ultimately the construction has been made. Construction has been made, my lord, since certain deviations are there, the proceedings possibly is pending at their end. That is the stage.
whatever it is, decide is representation.
Well, the thing is this, that he has made a lengthy representations, but all that is required for
He has made a
consideration.
lengthy repetition also.
Then what is the their word? Two words have been used in the section 397. If he points out these are the material misrepresentation or fraudulent statement in the notice,
That will come before
that
you.
that could be easier for us to, instead of
265.
going in detail of the representation, that everything for consideration by the authorities.
When he comes before you, you ask him whatever.
My lord.
What?
My landlord and mine.
everything. From 2011 till today. And
Whether-
all the suit have been owned. Because I've been purchased the property from the bank.
From the,
From the bank. Before that property was hypothecated.
he's the neighbor, right?
I know. But
what-
I've been harassed because, my lord, the private respondent age is 26. Lady. And the husband is
You have
86.
you have a problem before going before the authority?
I don't-
Do you have a problem in going before the authority concerned with the
No,
municipal? No, no.
All this.
But the formal report which I have received, my lord, be kept to the record, my lord. Regarding that construction part, that already when building has been constructed and a person is in occupation, that is the report. And your lordship direct, my lord, that I will be taking into consideration.
That report, I am not getting into the report. I'm just, you decide the representation. That will be
Your lordship.
conflict. Take down. The petitioner in the present writ petition is challenging the building plan, huh?
Page 263, building plan number, date, is being given in the subject.
There in,
Page 263.
yes. Is challenging the building plan, sanction building plan being numbered 201-414-0604 dated 30th-12-2024, 2014, sorry.
14, my lord, long back.
2014, Qua premises number 311 Becharam Chatterjee Road, Calcutta. Borough 14, ward number 130, police station Parnashri. The petition to have been obtained by fraud. To have been obtained by fraud. Full stop. This is the only thing?
No, Milord, the page 266, I have also said it, that apart from challenge of 400 proceedings should be drawn up since there is a admitted deviation.
In the alternative prayer that the demolition of the illegal construction shall, in the alternate, he also prays for the demolition of the illegal construction. Unauthorized and illegal, alleged unauthorized and illegal construction. Full stop. The
So far as the proceeding is unauthorized construction, my lord, the proceeding is pending as
And
per the rule. So far
that's
as
why I said alleged and unauthorized.
that- my lord, so far as we have already initiated proceeding while unauthorized for us.
So there is admitted unauthorized construction.
That has been mentioned, my lord, in our report.
And a check on a dispute being brought up between the accept convention the body with regard to possession of land along the structure. That should be done with state of fund section. It's worth that should transfer. Supporting transfer. The present case revolves around a property dispute, qua the above mentioned premises, where the private respondent number 10 allegedly obtained a building sanction plan, though through fraudulent means by falsely declaring that the land is free of all encumbrance, despite ongoing litigations. Full stop. The petitioner claims that the respondent number 10 not only misrepresented false facts to secure the sanction plan, but also constructed a G+3 storied building that significantly deviates from the approved plan, including unauthorized additional rooms, altered lift space, and increased tenement sizes. Full stop. Despite representation dated first representation was 14/3 and 31/10/2025, 24, sorry. The respondent has failed to act upon the same. Full stop. Thus, the petitioner has preferred the present writ petition. Learned counsel for the respondent. This is KMC, right? Respondent, Calcutta Municipal Corporation, Mr. Alok Ghosh states that he is ready and willing to consider petitioner's representation dated 31/10/2024. Full stop. Learned counsel for the petitioner states that he shall be satisfied if the same is decided within a time-bound manner. Full stop. In view of the statements made by the learned counsel for the parties, learned counsel for the private respondent 10. उससे पहले डाल देना. Learned counsel for the private respondent 10 also agrees to place his case before the respondent corporation if the representation is considered. Full stop. उसके बाद कर देना. In view of the submissions made by the counsel for the parties, this court directs the respondent. Which respondent, Mr. Ghosh? Executive engineer? That would be respondent number 5. Respondent number 5, right?
5 minutes.
Respondent number 5.
5.
To decide petitioner's representation dated 31/10/2024 within a period of 8 weeks. Mr. Ghosh, within
8 weeks.
Can you see 8 weeks here, Shiva?
within 8 weeks, in accordance with law, after affording from the date of communication of this order, in accordance with law, after affording an opportunity of
8 weeks.
personal hearing to the petitioner as well as the private respondents or any other stakeholder by way of a speaking order with the above direction, the present writ petition is disposed of. Affidavits are not exchanged.
Dispose of.
Disposed.
Yes.
Well, this is my application, this is my affidavit of service affected.
Well, I'm the municipality. Next.
The answering municipality. Answering respondent. Lordship, kindly first come to, I'm a tenant in respect of a property, in respect of a showroom, having a trade license, my lord, page 24, my last renewal. Kindly come to page 61 once. 61.
Yes.
Page 61, Lordship. My lord, this suit is filed by me against the illegal attempt of the present landlord, the developer, to evict me without due process of law. Thus, there is an interim order of injunction I obtained. This is subsist and subsequently, which is not annexed here, will subsequently develop. That is, my lord, 151 police help to carry out the order has been passed by the court. Now, in spite of that, my lord, kindly come to my complaint 56 and 63, mainly 63. In violation of that, my lord, the developer trying to, in connivance with the respondent municipal authorities, to my tenanted portion where I am running the business. So this is my grievance, not to do this. So I before your lordship.
But they are entitled to demolish a property.
My lord.
If there is any unauthorized illegal construction.
No. I am the tenant in respect of a property. I am running a business by a valid trade license, page 24, the last renewal. My lord, no question of unauthorized, authorized. Now the developer took the property. Now in connivance of the municipal, having the influence, in connivance of the respondent municipal authority, they are trying to demolish. I am not standing where.
Where is the demolition order?
My lord.
Where is the demolition
order? No demolition order, my lord. They are demolishing in connivance with the respondent. They come with the police and the municipal authority trying to demolish. My lord, kindly come to page 61 and 63. This is my complaint. So municipality has not, my lord,
61 is the order, sir. It's not
61 order, then my lord kindly come to 63. There is a police station and my lord the 60, sorry, my lord 66. 66. Page 66.
What
My lord,
is
kindly
the
see. I am writing to the chairman, my lord, refraining the municipal my lord, personnel not to, my lord, touch my property.
Where is the demolition order?
Demolition, or they are coming without any order, they have come and trying to demolish. My lord. This is the process.
What is it?
Well, municipality, this is the report which has been submitted. They filed another writ petition in another, that's same things.
Same, what same thing? Mala another writ petition at their instance, they are trying to cancel my trade license. Pursuant to your lordship direction, that was opportunity hearing was given and my trade license was remained. And another is by the police in action. And this is one of the atrocities of the respondent municipal authorities. Unless, why are you coming before your lordship, my lord? I have the difficulty, so I come before the court of law.
State what you have to say. Where's the demolition order, sir?
Yes.
My lord, that municipality had take steps. That's why I'm mentioning. They have been stating that
Your steps are for demolition. Where's the demolition order?
they made an application for sanction of building plan. That is no unauthorized.
Where is that?
My lord,
Where is that?
they applied before the municipal authority.
File your report.
Very well, my lord, I filed this report.
File your report.
You
can't take demolition action without passing a demolition order.
No, I am not taking. I am taking direction. Your lord shall give me information.
You read it?
I am reading, my lord. I am to inform you that as per your letter, that is addressed to the Misty Construction, that is a developer. To this office, such and such, this office has granted permission for demolition of the existing structure located at 33 NS.
So how come you have given permission for demolition?
My lord,
How come you have given permission for demolition? That's what.
they applied for sanction plan. That's why, my
Sir, so somebody will apply for sanction plan, you will give a demolition order. Sir, what are you reading?
my lord, I have been taking. Number one, please
I think
ensure
you know
all
what
the
you are reading.
necessary safety
Sir,
and
sir, sir,
measures.
I don't want to.
I give the report, my lord.
I don't want to embarrass you. You know what you're.
No, I am not controversing your lordship. I have submitted report, my lord.
Read the order.
I think I have cleared my case.
The petitioner in the present writ petition challenges the petitioner in the present writ petition has approached this court against the threat of demolition of his property premises number 33/NS Avenue, Sirampur, Hubli, full stop. He states that there's a civil suit pending, civil suit number 478 of 2024 pending before the civil judge junior division Sirampur, wherein an interim injunction dated 27/8/2024 has been passed in favor of the petitioner from dispossessing him. Full stop. It is the case of the petitioner that he is the tenant in the above mentioned property and that the landlord in
having trade license space 24, last renewal.
in collusion with the respondent municipality is trying to demolish his property without following the due process of law. Full stop. He states that without any demolition order, the petitioner has been threatened with demolition action. Full stop. He has made representations before the municipal authority on 19/11/2024 but till date has the respondent authority has not acted upon the same. Full stop. Learned counsel for the respondent municipality has handed over a copy of the instruction. Just give me this.
Sir, apna copy take.
Has handed over a copy of the instruction, which instruction dated 12/11/2024, which shows that, which reads that a permission for demolition of the existing structure has been granted, though there is no order to support the said demolition action. Full stop. Learned counsel for the respondent municipality seeks and is granted 2 weeks, 3 weeks?
3 weeks.
3 weeks time to file his report by way of an affidavit. A reply, if any, to the same within 1 week thereafter, list after 4 weeks.
Malad, in meantime, I protection, malad, so that malad no coercive action.
There is no protection.
Malad, otherwise, malad, if they have demolished my portion, malad, then
Nothing
it will become
demolished.
infectious, malad.
Nothing will be demolished.
Mr. Lordship, can I direct me to hand over the report which has been submitted by the
What
There
is
no coercive step has to be taken, malad.
their report is nothing.
Oh. Demolition what stop was as per his.
Last page of.
Malad, then can you record this one?
Sir,
If we instructed to
I'm
stop.
telling you, I will dismiss your petition if you interfere. You have a very bad habit, and please don't do this in this course. Don't interfere. You have made your submission. We have heard your submission. We have recorded.
I'm apology. I'm tendering my apology.
Then you should not speak. Yes, madam. What are you saying?
Last page of my report shows that the demolition work of the site has remained stopped now, and the petitioner Vikas Shah is running shop right now, my lord. It's 12, paragraph number 12, my lord. Last page. For annexion, before starting of annexions, my lord.
Before the annexion.
Before the annexion.
Yes.
Last page, paragraph number 12. The demolition work of the site has remained stopped now, and the petitioner Vikas Shah is running his shop.
A report filed by the state is taken on record. The report indicates that there is no demolition which is taking place on the site. Full stop. Let this matter be after 4 weeks.
May I bring one indulgence, malad? Can I get a copy of this report, malad, submitted by learned friends?
He has not submitted any report. The report will be submitted by.
I'm good.
You keep the instruction. Instruction I'm keeping on record, sir.
Yes, sir. Get it. Get it. Get it.
You are for?
Teams.
Not for the petitioner. That's why I asked.
My instruction is that, my lord, we have auctioned the property, and my lord, we have no role as such in this matter to play.
The auction purchaser. Page 51. This will come in many of the matters. This point would be coming. Another is pending that Mr. Kaur is appearing. Now, my lord, fourth line from the top, your lordship sees. As is
Where is basis?
As is, where is
what
basis?
Basis.
Hmm.
This is the condition of e-auction. The court had the occasion, and this is a surface issue. Court had the occasion, our court, division bench, had the occasion to consider this clause following K.C. Ninan of the three judges bench of the Honorable Supreme Court. And this is the judgment of our court.
Just hand over.
Indian Bank Limited versus
Hey,
Gap Olive Oil. But paragraph 18 onwards is very important. Though the Honorable Division Bench has quoted para 146, but I think 143 is also very important. From paragraph 18 onwards, the law on the subject has now been settled by the Honorable Supreme Court in a recent decision in K.C. Ninan versus Kerala State Electricity Board, where the Supreme Court was considering several questions, one of which being implication of the sale of the premises on as is where is basis. And that is the
as is, where is
which basis with or without reference to the electricity areas of the premises. The said condition was explained to mean that a sale on as is where is basis postulates that the purchaser would be acquiring assets with all existing rights, obligations and liabilities. When a property is sold on as is where is basis, encumbrances on the property stands transferred to the purchaser upon sale. Very clear terms.
Yes.
Now, my lord, the Honorable Court, while dealing with K.C. Ninan, just in the next paragraph, paragraph 19, has quoted paragraph 146.
146.
But, my lord would excuse me. One 143 is more important than 146. My reading of the judgment. My lord,
Yes.
pardon me because I have marked it very heavily. 143 is very important.
That's the implication of expression.
Thus, the implication of the expression as is, where is, or as is, what is basis, or as is, where is, whatever there is, and without recourse basis is not limited to the physical condition of the property, but extends to condition of the title of the property and the extent and the state of whatever claims, rights and dues affect the property unless stated otherwise in the contract. The implication of the expression is that every intending bidder is put on notice and that the seller does not undertake any responsibility to procure permission in respect of the property offered for sale or any liability for the payment of dues like water service charges, electricity, dues for power connection and thereafter taxes of the local authorities. I am a local authority. I have got dues so far as the property is concerned. I have put a padlock since the dues are not being paid. And he has come challenging that, saying that I am an e-auction purchaser. Kindly provide me relief. Let him pay the dues. I will open it within 48 hours. And he has offered to pay 4 lakhs. If your lordship sees on 26 now, the next annexure, page 50.
Page?
I'll just show that.
Notice.
Page 62, paragraph after discussion presently. Page 62, your lordship is. After discussion presently by and between you and my client's representative that you are requested to waive all your interest penalty charges in respect of the amounts claimed in the 2 notices. The amounts of being atho and atho. The said amount of the same may be directed to be paid in 24 installments. My client on the table itself offers you 4 lakhs at present. So he accepts the livelihood. Not that he doesn't accept the livelihood, he accepts the livelihood.
None for the petitioner. No one is here. And these are all mentioned and then listed here
Yes.
on mentioning. And nobody comes.
Unfortunately.
And they make such a hue and cry. And I remember this one. My property getting sealed, my property getting sealed. And
It is already sold, and the auction purchaser brings in the claim. So far as the bank is concerned, bank has no role to play in this writ petition.
Keeps this judgment of our division bench
yes,
separately, because it would be required at least in my
I'm-
mind. There
I'm-
are 3-4 matters
I'm keeping this.
that will come into that country that Mr. Joydeep Kaur's.
Because
There also it will have a full force of that argument being forwarded that I am not in the know of the dues because I am a e-auction purchaser, that will not come to any help.
that's more helpful. We'll make it not today then. I can dismiss in default, but not good. Let him.
Thursday there is some day after tomorrow.
Day after.
If the petitioner doesn't
Petitioner, none for the petitioner. In the interest of justice, adverse orders are deferred. Let this matter be listed on Wednesday. Yes, yes. Supreme
I'll
Court.
leave it in that other matter. Full bunch I have kept it ready in that matter.
I'll keep this one.
Yes, your lordship keeps it.
it will be lordship pleasures to note that bank can be released from this matter. We have no role to.
Why you don't like? You should be happy appearing. Every appearance you can build.
Grateful.
Appearing for the corporation. Unauthorized construction, sanction granted G+3, but the petitioner constructed 2 additional floors of unauthorized construction, violation of the sanction plan. Corporation started demolition proceeding, and special officer passed an order of demolition of upper 2 floors. And in the petition stated, they filed an appeal before the authority, before the building tribunal of the corporation.
They have already filed it.
And no stay is there.
No, have they filed it before the tribunal?
Before the tribunal, they filed. It
Then
is stated in the petition, but no PT appeal number is there.
How is maintainable then? Dismiss in default.
Paragraph 12, my lord.
Dismiss in default, madam. Let them pursue in the tribunal. Mr. Banerjee, this tribunal is for Howrah?
Tribunal Howrah has been
Now functional is Howrah.
Commissioner Howrah.
And what about KMC?
KMC.
Special officer.
No,
No, tribunal.
There is a tribunal. There is a tribunal.
Tribunal is a functional.
Functioning.
So 2 are functional and the rest of them? Why don't you get a notification issued for the rest of them?
And it is written there, if the tribunal is not functioning, High Court will then have to take.
No, that's right. But now it is functioning. You should get a notification issued.
I have to. Howrah, no.
KMC.
KMC is functioning.
No, Howrah is also functioning.
Howrah constituted, but it is not functioning. It is very unfortunate.
No, that day you told me it's functioning.
Functioning, but no, it is not sitting. It is a problem.
No, but some officer has been appointed.
Appointed, but I don't know what is happening. It is not functioning at all. I've been told that it has been constituted, everything has been done. And we have to go there also. It is a problem for us. But still we have to go there. But
In Kolkata, it is functioning. And in the building of Kolkata also, it is constituting the Kolkata building itself. Not in Howrah.
Not enough. Dismiss in default. None for the petitioner, dismiss it.
29, my lord, I am for the petitioner. This is my affidavit of service. Your Lordship, there has been a stop work notice issued by the Haldia municipality. In spite of that, the private respondents are continuing with the illegal construction. I have made several representations. The municipal authorities have given me a
There for the
hearing.
municipality.
There is no private, unauthorized construction. I have making construction as per the sanction plan.
You are for the municipality. Consider the representation, decide.
Well, kindly come to page 54 once for the order passed by the municipality. There was a dispute with regard to the common passage between private respondent and the petitioner. Municipality direct the both of them to mitigate this dispute between pending before them. Your Lordship, kindly come to page 54 once.
54 is in Bangla.
May I read it further? Yes. They said on 30th September 2024, a hearing was conducted by the municipality where it came into knowledge that a private dispute is going on between the petitioner and the private respondent, and they direct the private respondent to mitigate that dispute with the petitioner.
My lord, may
That
I
dispute with
read the
regard to
paragraph?
common passage. I have a sanction plan. I am making construction as per the sanction plan.
My lord, may I read the paragraph and translate it for my lord?
Yes, yes.
একটি অভিযোগের ভিত্তিতে ইংরেজির অমুক তারিখে একটি শুনানি করা হয়েছিল। এই শুনানিতে নিজেদের মধ্যে আলোচনা করে বারাম রাস্তা সংক্রান্ত সমস্যা মিটিয়ে নেওয়ার কথা বলা হয়েছিল। There was a hearing on such and such date when the municipality said that come to an amicable settlement regarding the common passage, 8-foot common passage, your lordship. 4 feet belongs to the private respondent, 4 feet belongs to me, your lordship. Thereafter it states, your lordship, এই সমস্যা না মিটিয়ে নেওয়া পর্যন্ত ঘরের সমস্ত কাজ বন্ধ রাখতে হবে।
So if the solution is not there, then you have to stop
construction.
Yes.
কিন্তু আপনি শুনানির সিদ্ধান্তকে মান্যতা না দিয়ে কাজ করে চলেছেন। This is addressed to the private respondent, your lordship. You have not given any heed to the conclusion of that meeting and
carrying on
with the construction. অবিলম্বে কাজ বন্ধ করে সমস্যা মিটিয়ে নেওয়ার জন্য অনুরোধ করা হচ্ছে।
So you stop the work till the time you find a solution.
So now I will kindly take up section 220. Yes. In which condition the municipality can issue a stop work notice. If there is an unauthorized construction, then the municipality can issue a stop work notice. But if there is a private dispute between the petitioner and private respondent, municipality cannot ask both of them to mitigate that dispute.
May I read the paragraph before that, wherein lies the dispute?
Yes.
বর্তমানে পরিলিখিত হচ্ছে যে প্রথম বিল্ডিং প্ল্যান, there was an earlier building plan that was sanctioned which was subsequently cancelled. It was a 6 decimal land. I have purchased 3 decimal from his brother. He is the owner of 3 decimal yet. There's an 8-foot passage which 4 feet belong to the one brother, another 4 feet to the other. বর্তমানে প্রতিলিখিত হয়েছে যে প্রথম বিল্ডিং প্ল্যান সাবমিট করার সময় বাড়ির পার্শ্বে বারাম রাস্তা দেখিয়েছিলেন। পুনরায় সংশোধনিত প্ল্যান জমা করার সময় বারাম রাস্তাকে আড়াল করে গেছেন। In the previous plan which they had submitted, there was the common passage which were shown. Subsequent, on the basis of which they say the plan has been sanctioned, that plan does not show that common passage, your lordship.
Okay.
What they have done is they have shown my 4 feet as the common passage for them. They say that is their 4 feet. There's a dispute. There's an illegal construction, admittedly.
Who's for the municipality?
Nobody is appearing today.
And the municipality has
Which-
Haldia municipality.
Who's the council? Any idea? Just see Haldia. Hey. No?
May I serve a notice
Yes.
upon municipality, your lordship?
Serve a notice
But only
upon the
one thing, I have also preferred a writ petition challenging the stop work notice that is appearing as item number 1839 of monthly list.
Just
Let
take down.
both they appear together, my lord.
Just take down. The writ petition number so and so shall be tagged along with the present writ petition. Learned counsel for the petitioner seeks to serve afresh on Haldia
Municipality.
municipality. Let this matter be listed on
2 weeks later, your lordship. Haldia.
2 weeks. After 2
Grateful, your
weeks.
lordship.
Tag kar dena. 21st July. Tag that matter. Give the
I'm giving my lord the number.
1839.
Great clear.
But I'm for the petitioner led by Mr. Banerjee, my lord. Perhaps Mr. Banerjee is on.
Lord, I beg to address your lordship, my lord, on virtual mode, my lord. Your lordship kindly permits me, my lord.
Yes, Mr.
This is, my lord, one of the biggest multi-speciality hospitals of Durgapur, my lord. We had put in an application for consideration of revised building sanction. It is our case that that application for revised building sanction is yet to be considered. That is languishing before the authorities. Only prayer today I was making is, without deciding anything on merits, if your lordship kindly directs them to dispose of that application after giving me an opportunity of hearing and to pass an order saying whether it is allowable or not allowable.
Page 135 is the.
I have no further submissions.
Page 135 below is.
We have not.
Yes, Mr. Banerjee.
But we have not issued any demolition notice also regarding this. Only one thing, my lord, that what they have claimed, that I am showing, they are claiming that the FAR that they are entitled to, FAR. Page 130 is that representation where they have stated so. Page 130.
ওয়েস্ট বেঙ্গল কর্পোরেশন একটা আছে ওয়েস্ট বেঙ্গল আনতে বললাম তো ওয়েস্ট বেঙ্গল বিল্ডিং কর্পোরেশন একটা আছে বললাম আনতে
Lord, why I was trying to not cut the matter short is that the authority has not given any view. The authority
No,
gives us
Mr. Banerjee, first we have to understand whether the authority even can give you a revised sanction building plan, because it's a construction which has already taken place. So you're not seeking a fresh sanction to a building. You have already constructed in the second phase. You have taken the FAR of
1.7. 1.7.
2.74 he has taken. 1.7 was the one which you had sanctioned.
Yes,
He's saying that he's
yes.
entitled
He's saying
to
that 1.05.
2.75. He's entitled to 2.75.
Yes,
He has used 2.74. You have sanctioned 1.7.
exactly. That was my lord has come to the point.
That is what
Now,
it is.
now their claim is that we have given a revised plan. 1.05 is not only not utilized by us, if that it be considered or not. But representation has been given, we can consider that. If it is legally viable, we will do it.
Milord, I do not want to open, Milord. Mr. Banerjee is there. There are, Milord, regulation to that effect. That's why, Milord. It's
No, but then for the yes, well, it is for them to say. Yes.
We are not expressing any opinion.
Yes, yes. Well, I'm deeply obliged. Deeply obliged.
At that point of time, we have given 1.7
1.7
out of 2.75. Now they are claiming that in
and
the
they have
corona,
utilized 2.74, much beyond what you had given, but they say that they can use it because of the regulation which are in
exactly.
My lord,
And due to corona period that they have utilized that
in 2020
at the time of corona.
exigency of.
yes, yes, that too we had to do because of the state directions of creating more wards for the COVID patients. So,
But my lord, while asking us to consider it, my lord will make it clear. For that reason, I am saying I have to say that on the basis.
Reject it. But
I have rejected. So my lord have to make it clear. Otherwise,
yes,
I
yes, my lord is sending for
whatever you have
consideration.
to do.
Whatever you have to do.
If I, Mr. Banerjee, give any kind of
view, then that will be binding. Yeah.
That will be
binding on you.
As your lordship.
I
cannot.
give binding, then I have to ask for affidavit of opposition. Then
yes,
complete the procedure and process, and then give a judgment.
Otherwise, yes, that is there. Otherwise, my lord, we can file a report regarding that.
No,
report
Mr.
will not happen.
The
report in this will not
happen.
As your lordship.
I'm grateful to your lordship.
Petitioner has preferred the present writ petition being aggrieved by the inaction of the respondent in not disposing the petitioner's application for sanction of the revised building plan submitted on 23/8/2023, in respect of plot number C1 over CS plot number 220 bracket OP, bracket P, Khaitan number 147, 151, 163, Mauza, Gopinathpur, jail number 85, PS, Faridpur, district, Paschim, Bardhaman. Bracket holding number 6N, ward number 27, street, Market Street, sector 2B, Durgapur, bracket close. This is the address?
Perhaps it will be 7N subject to my lord.
7 capital N.
7/N. My lord has subject.
6N.
Oh,
6.
Oh, page 28 shows it 7N.
Page 135.
Oh.
It's 7. It's for phase 2, Milord.
Phase 2.
Phase 2.
But you're asking
7.
for,
Milord?
You're asking for phase 2 only, right?
Phase 2.
Yes.
Phase 2. Phase 2. The holding number is 7.
Holding number 7.
Yes, yes.
Holding number 7/N.
7N.
7.
7N. 6 है ना? 6 का 7 हो जाए.
So representation is at page 141, 23rd August.
That's what I'm saying.
There are several representations.
Yes, yes, obliged.
And that is the latest, I think.
Ward number 27. Ward number 6. Property 6N. The petitioner is operating a hospital under the name and style of Citizen Hospital at plot number C2, right? In association with the IMA, Indian Medical Association, bracket IMA. Full stop. With the intention of expanding the hospital, the petitioner, through the owner of the adjacent plot C1, Mr. Ashwin DAW and Dawn applied for a building sanction, comma, which was duly approved on 3/3/2022, full stop. Pursuant thereto, comma, the petitioner commenced construction at plot number C1 in accordance with the sanction plan, full stop. However, during the course of the construction, certain technical requirements necessitated revision of the original plan, full stop. Accordingly, a revised building plan was submitted by the petitioner on 28/3/2023, full stop. 23rd August 2023, full stop. Despite repeated follow-up and representations made by the petitioner, made to the respondent, comma, the revised plan has not been processed or sanctioned, full stop. In the meantime, the petitioner proceeded with the construction in accordance with the revised plan and has completed the building and commenced operation therein, full stop. However, till date, the respondent has neither revised the sanction plan nor has acted upon the representation of the petitioner. Being aggrieved by the same, the petitioner has preferred the presented petition, full stop. Learned counsel for the respondent municipality, Mr. Sandeepan Banerjee, states that they are ready and willing to decide petitioner's representation dated 24 January 2024, full stop. Learned counsel for the petitioner states that he shall be satisfied if the representation is decided within a time-bound manner, full stop. In view of the submissions advanced by the counsel for the parties, this court directs respondent number,
Commissioner, my lord.
respondent number,
Commissioner, my lord.
Commissioner, please.
My lord, respondent number 4.
respondent number 4,
4, my lord, page 3.
respondent number 4, to decide petitioner's representation dated 24 January 2024 within a period of
12 weeks, my lord.
12 weeks, within a period of 12 weeks
After giving an opportunity of hearing and
from the date of passing of this order in accordance with law, comma, after affording an opportunity of personal hearing to the petitioner as well as any other stakeholder by way of a speaking order,
my lord.
full stop. With the above direction, the present writ petition is disposed of. Affidavits have not been exchanged. None of the contents are admitted.
Grateful.
Deeply obliged, my lord. Obliged, your lord.
Deeply obliged. Get a KMC.
तमाम पर थोड़ा दिमाग लगा लेना, वो जो कंस्ट्रक्शन है ना, देख लेना प्लॉट्स
My lord, Mr. Imtiaz Ahmad is appearing on behalf of the petitioner. He was here.
KMC, my lord, I have got the instruction also.
He was here all along, my lord, but due to some medical emergency, had to leave. So I will be praying for not today.
I'm grateful that he was here all along.
My lord,
We are also here all along.
my lord, I can understand, but that was the instruction I have.
Yes, what is it, Mr. Banerjee? We'll have it
I have the
tomorrow.
report.
Tomorrow.
Well,
My lord, a small instead of tomorrow, my lord, can we keep it on Wednesday? Because if my senior doesn't come tomorrow as well, I have to take.
And I'll dismiss it, or you argue.
My lord,
How much indulgence? You're like the camel.
Well.
You give this much space, you take this much space.
grateful, my lord.
Rest of the matters tomorrow.
Well. I'll have it.